y'all. What's good? Can everybody hear me okay? Y'all, I just woke up from this epic nap. Okay. I appreciate an adult nap. Okay. How was everybody's day? I woke up super tired because I had insomnia last night after we got off the live. And unfortunately, I was not able to sleep. It was like a conscious sleep. I don't know if anybody's ever had that where you it's like you're resting and almost sleep, but you can hear everything. You're fully aware of what's going on. That's what I experienced last night. And it's not the first time either. So anyway, I went through that all night, and then of course I woke up before my alarm and could not go back to whatever resting state that I was in. And so I got up and went to work, and it was crazy busy because it's the holiday season. So I went through that. I came home, I ate a little bit, and then I had to lay my burdens down. Okay. So now I'm here with all of you. So we are going to do a little roll call real quick. Hey, dog mom. My boo dog mom is here. Hey, girl. If you want me to drop the link for you tonight, let me know or whatever. I know we had discussed that previously. So let me know, girl. Sparky. Oh, you got a new job too. Oh, I miss you on here. Oh man, I hope you can stay or maybe catch any of the lives later this week. I think I have 3 scheduled. So I miss your friends. Hey, Elizabeth. Yeah, girl, get your coffee because you know we cut up on here or whatever. I hope you had a beautiful Sunday. Hey, Debbie. Good to see you. I'm so happy to see you. Hey, Maddie. What's up, girl? Good to see you. Excuse me. Oh, awesome. What colors did you go with? My daughter put the tree up November the 1st at midnight. She does not play about her tree and her Christmas decorations. We got a new tree this year. It's a little taller and she decked it out. So let me know what color scheme you went with. Hey, Jeff. Good to see you. Hope your Sunday was beautiful. Hello, hello. Hello, Kelly. Listen, we go from this one to that one to this one. Okay, and circle the block again. Hey, Bluesy News, good to see you. Hope you had a great day today. Hey, Boo. Should I call you TY? How you doing today? I hope you had a great day. Hey, Bridget. Isn't it the worst? And it's probably a little TMI, but y'all know me. Like, I am entering perimenopause. And so that is one of the symptoms that you have, along with the night sweats and the cravings, the weight gain, the headaches, and all of those beautiful things, right? And so I'm pretty sure I will probably have a little bit of that again tonight because I took a nap. Uh, so it is what it is. I'm just rolling with it, right? Great. I'm glad you guys can hear me. Okay, so let me see if there's anything else I need to discuss prior to hey Mika, good to see you. Hope you had a beautiful Sunday. Um gosh, I think I have some comments I needed to it's easier for me to address comments while I'm on live than typing them out. So let me see if y'all don't mind real quick. Let's see. You know what? My kids are so low maintenance to where if that's what brings her joy, I am all for it. I have been doing my best. Her and her father, both of us together have been trying to raise all of our kids, without expecting anything from anyone. What people give you is what they want to give you, and just find joy in what you already have and in helping others. And so she's done an amazing job with that. And so if that's the thing that brings her joy without us having to stress out about other things that she could potentially be involved with, I'm grateful for it. She is 16, no pregnancies, no bad relationships. She hasn't had any surgeries, no serious illnesses. She does mouth off a little bit, but other than that, she is a very sweet girl. So I'm gonna let her have that tree up on November the 1st, okay? Oh my gosh, right? I should have just got out of the bed and just tried to do something else, but I was trying to thug it out, okay? Okay, let me go through these comments real quick. Somebody from the last live says, "Why does a judge keep saying you may not instead of saying you will not?" I don't know. I think it's just her being polite. I really don't have an answer to that. Um, somebody said Jay Queen is a fool. Unbiblical cord. That got a lot of y'all. He said he got to cut the unbiblical cord. I can't even say it. Somebody said, "Why does he look like a Bratz doll? His closing was a joke. He won't argue the facts because the facts point to his guilt. He has some nerve to talk about forgiveness. All the people around him have restraining orders against him. What a clown." And then they go on to talk about being a narcissist, but I do not like the word narcissist, nor do I like to explain or attempt to explain or attempt to understand narcissistic behavior because I despise the word narcissist. And it is no shade to you, Julie, but I wish the word narcissist would disappear because it seems to me that ever since that word came out, everybody uses it. They can't stop using it. So I will not go into that. Let's see, was it anything else? A lot of people were shocked that his mother sent letters to the victims. Yes, she did. Basically saying that her poor precious baby did not have a fair trial and that he didn't do it on purpose. He didn't mean to hurt nobody. So yes, I'm sure that was a shocker to a lot of people. Let me see. Unbiblical core. Somebody says, "Sorry for all the comments, but oh my God, he really pisses me off. The whole world has spent weeks with this imbecile. And what we all have seen proves you are the type of person to drive your SUV through the parade and unalive and injure so many while he has absolutely no self awareness." Let me tell y'all something. I understand that, a lot of people are still upset and probably will always be. Don't let this man get y'all in y'all feelings. You know, There is never anything or anyone that will upset me to that point. You gotta keep living your life, you know? Say what you gotta say, and that's that. Please don't let this man disrupt your mental health to the point where you know, you going off. There was somebody else that just had to absolutely leave the live because they were so upset. No, don't let him upset you like that. He did something terrible, guys, but I don't want this to be that. Let me see. Somebody asked about, is there paternity action going on with this said newborn? I have not read, seen, or heard anything like that. I don't believe there was a newborn. In fact, I don't even know when he would have met up with somebody to impregnate them and the baby would be a newborn, given the fact that all the pre-trial goings on was for a year. So I'm not sure about that one. I think he was just trying to garner some sympathy. The same person went on to say that they wonder if Brooks has ever given the jury their rounds of applause. Let me see. Someone then went on to explain to me how they can prevent the car from causing injury to anyone if it accelerated. I appreciate you for that because I have no clue anything about a car except for oil change, putting gas in the car, pressing the brake, and pressing the pedal. My husband takes good care of me as it relates to my car. So unfortunately, I don't know much about that, but thank you. Um Somebody says they love my take and my laugh. Thank you so much. I'm glad you guys love my laugh because listen, I love to laugh and I put my mouth deep in this microphone when it's time to laugh. Okay. Somebody said, "Who stepped on his ears?" That took me out. And then someone else that I've never seen before says, "I don't agree with you. I don't disagree with you that Judge Doro went above and beyond with this idiot. However, I comprehend her reasoning in doing so because she was trying to keep the record clear so that she would have no grounds when he went for appeal. It is certainly easy for us to play Monday quarterback with this trial." Somebody else said that before. Monday quarterback. I think I heard a lawyer say that before. I don't know who you're quoting here, but They say, but ultimately, her goal was to one, get him convicted. We know that. Two, make sure there were no grounds for appeal. Three, ensure that the people who were damaged by his criminality did not have to go through another trial and could truly put this issue to bed. So I'm glad this person commented and not to be shady, but it prompted me to want to follow up with this in a video. And we are going to go over what his potential grounds for an appeal will be. Now, what we all have to understand is that he filed an intent to appeal, so he didn't officially appeal. Once you are convicted of a crime, you have 20 days to put in a notice of intent. He will have a public defender. His name is Michael Convoy or Boy Convey, something like that. This person will then read through the voluminous transcript and see if there is any legal grounds that need to be appealed on. So, Judge Darrell explaining things thoroughly in the fashion that she chose to will not it won't make or break his chances for an appeal. They have to look for other things that I'm not going to go into because that will be a video. Additionally, if that lawyer does not find any grounds to file an appeal, he won't. If he does, then a trial judge will listen to his argument and then they will determine if there is suitable grounds for an appeal. And then it will go to the appellate court. If the trial judge says, no, you don't have grounds for an appeal, then that attorney or another attorney can then appeal to the Wisconsin Supreme Court. So it's levels to this thing. Okay. But we're going to go into that in another video. My boo Debbie says, glad you enjoyed your wine. I did, Debbie, and I'm going to have some more in a few seconds. Uh-oh, somebody's upset. Someone says, wow, 5 seconds into the video, followed by 5 minutes of commentary. Sure sucks. Oh boy. Y'all gotta understand this is a commentary channel. But there are other channels that don't talk. So I don't really know what to tell you, my boy or my girl. All right, that's enough of that. All right, let's get to the meat and potatoes of this thing. Let me catch up to these comments. Debbie says she loves doing it all. She takes good care of me. That is amazing, Debbie. That is amazing. He stay lying, don't he? Hey, Tim. Girl, bipolar, narcissist. I think I heard social path. Y'all can say what y'all want. I ain't telling nobody what to say, but I'm over it. I need something else. Hey, dog mom girl. Yes, ma'am. I'm gonna do a little bit more research for another video pertaining to that. Matter of fact, let me write that down so I don't forget. Letters to the victims, Don Woods. I'm sorry, hold on. All right. Thank you and welcome. I don't think I've seen you here before, but welcome and thank you so much. Hey, Debbie, there you are. Hope you had a beautiful day. Oh my goodness, I'm so glad I get to be in this chat and I get to see this live and I get to be here for it. Yes, yes, yes. All right, let's jump into the meat and potatoes of this. We are going to listen to Darrell Brooks, aka third party intervener, cross-examinate. Mr. Detective Casey. Thank you so much. I appreciate it. Some people just want to, let me tell you something. I have gotten to the age where I don't have to prove myself or prove anything about myself to anyone. Some people just want to have something to say to be a part of something. And that's cool with me. That's cool with me. I mean, sometimes I get a little petty and I clap back, but for the most part, I don't care. But I appreciate y'all. Thank you so much. Okay, let's share the screen. Get this set up. All right. Excuse me. All right, let's go.
Intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
Right, the record should reflect that the individual known to this court as Darrell E. Brooks appears in person and in custody. He is in street clothing today, in a suit and tie, also wearing a mask. I checked with Mr. Brooks before calling the case if he had any documentation to provide to the court or to the state. I did look at a number of subpoenas for completeness, and the one thing I noted was that there was a date and time for the appearance that was not included. And so I just wanted to address that on the record, since of course this is a multi-day, multi-week trial. Typically individuals, whether it be the state or a defendant, would put the first day of trial on the subpoena unless there was some other information to suggest a different date. Obviously, we've already started, but I can ask the state if they, given kind of how things have been proceeding thus far, I know originally you had thought it would take 5 to 7 days for you to present your case in chief. Are we still on target for that from when we started the taking of testimony?
Yes, from when we started the taking of testimony, yes. Right now, we are projected to wrap up our case Thursday afternoon or Friday morning. So that would be within that 5 to 7 day range, Your Honor.
All right. Certainly would be reasonable if you picked a date, either Thursday or Friday, if they show up, which presumably they would, right? If we're able to get all of these, not me, but if the state's able to assist, given what they've said earlier in getting the subpoenas out, then even if we weren't quite to that point, I can certainly bring people in and let them know when to come back. And that's pretty typical.
So, just so I'm clear, so I put, so that would be roughly the 13th or 14th?
Today's the 10th, so.
Tired of this. Let's get to it. What we talking
That
about?
being said, Your Honor, I think it's a clear reference to the other acts, only if you know there's other acts. Truthfully, I think it's a vague and ambiguous statement. What I heard the statement to have been at about the 2:52 mark in the recording, I heard Miss Patterson say, "Me and my baby daddy, we fight all the time. We had an incident, he ran me over with a car." That's what I heard her to say. She does not say it happened in Milwaukee. She does not say it happened 3 weeks ago. She does not say I suffered a broken leg. To me, in the context of Miss Runkle's testimony,
Child. Sue Upper looked like she ain't had no sleep since yesteryear. Poor thing. She done gave her heart and soul to her career, and she is worn out. Leslie, too. Y'all see them bags under there? My God. I have so much respect for them. I truly do. I truly do. Y'all know how I feel about women in the law. I just had to stop to say that.
testimony last week, in which she testified that Mr. Brooks had swerved at Erica Patterson and that Miss Runkle had pulled her out of the way. I don't think the jury would have immediately thought Erica Patterson, when she made that statement, if they heard it, was referring to something weeks earlier in another county at another location. Really, the only thing objectionable about that whole quote I just issued would be the very last phrase, "He ran me over with a car." And again, if she's referring to the Milwaukee incident, it's not clear from that statement. I certainly understand, with the knowledge of the Milwaukee incident, there's a reasonable interpretation that's what she was talking about, but she may also have been talking about the events of November 21st, even to an objective standard on this record, Your Honor. I don't think the jury would have realized or appreciated she was talking about another incident. So I think the exhibit can stand as is. We could redact just about a 2 or 3 second audio from that recording where those words are removed. And I listened to it several times over the weekend. I think if we did that, it would not be that obvious.
Let me catch up on these comments. Let me see what y'all over here talking about and see who's coming in. Oh, dog mom. I just love the way you love on me. You are so sweet. I really appreciate you. I do. Right. That oversized shirt. And his mama, let me tell you how much of a liar she is. She sat up there and told the news reporters that she would bring her son clothes every day to wear. And that's a lie. Those are jail issue clothes. Why do they have to lie so much? I just don't understand. Oh my God. I can't stand him either, but don't let him run up your pressure. You free. Hello there. How are you? Hey, Terry. Absolutely, he does. He does. You asked me another question on a comment. Do you remember what it was? I don't remember it verbatim, but I remember you asking me something. It's so good to see you, Terry. I hope you're doing well. Blue and silver. What you talking about, Kelly? It sure is. She is a no nonsense, kick ass attorney, and I just adore her. I do.
Yes, so that the exhibit could stand in place. The officer, if you recall, the timing is he's getting out of his car and he's approaching them, and she makes that statement about he ran me over with a car, but then her very next sentence is there's nothing happened, nothing's going on, nothing to be worried about here. And she's essentially trying to convince the officer not to do anything. So again, I think that also supports our contention that if we strike the exhibit or we strike words from the exhibit, we may be calling undue attention to something that was very vanilla to this jury that they really wouldn't have thought twice about, given the testimony of Corey Runkle and Erica Patterson that was already on the record. So we would offer to redact that portion if appropriate, but it may also be appropriate just to leave it stand as is. And should they ever ask to see that exhibit again, we would prevent that from being played a second time.
Thank you. Mr. Brooks, do you have a position on this?
Yeah, I mean, it's obvious to me. I can only hear out of one ear, and I was able to hear clearly what was said. With all due respect, Your Honor, you made a ruling about this.
Does he not realize that most people that have impaired hearing, usually it affects their speech as well? You're partially deaf, yet there is nothing wrong with the way you speak, sir. And I wonder what his reasoning was behind lying and saying that he can only hear out of one ear. Is that going to be a part of his appeal? The grounds for his appeal, y'all?
Previously, in ample enough time before the trial even started, you made the ruling. I see no reason why the exhibit should be admitted into evidence. From my perspective, it's clearly obvious what was being referenced. I mean, if she was able to give any type of statement at that time to the officer, then obviously she wasn't hit at that time on that date on the 21st. She would clearly be referencing some other incident. Hence the reason why we argue all the time in this, that, and the third. It was clear to me what was being referenced, and because of the ruling, because of the implication in that statement, I believe the exhibit should be striked altogether.
Thank you for your position, Mr. Brooks. And the reason why last week I said I'm inclined to strike it, but I wanted to give the parties an opportunity.
Dogma. Girl, I know he can't talk. What I'm saying is, you know what I'm saying. Oh, has tried everything. I mean, exhausted every possibility. Do you hear me? Oh God. Now that I got y'all saying his bald head mama, I love y'all. His bald headed mama sent letters to the victims. No wonder she had to move and sell that house. Yes. I'm gonna do a video on it, okay? Darrell and his exhibits and this and that and a turd. She doesn't say Darrell Brooks hit me. She said baby daddy. Debbie, I despise baby daddy. I do. I can't stand it. You know, the only reason he's able to articulate what is going on is because he know he's the one to put the balls on her. That's all that is. That's all that is, you know? Ah, yes. I have trouble, and I don't care if you brought that man in there to test, what was it? The sound. Is it decibels, y'all? I probably said it wrong. In the other courtroom, I don't care what y'all say. The headphones didn't work correctly either. Y'all biased against me. Ah. Oh my goodness, I'm telling you. And the fact that every day they had to go back and re-strategize, you know? Every day they had to think of a way to one up him. That had to be exhausting. I know when I get off work, I don't want to sit and talk to anybody. I want to go home, all right, take my bra off, take my shoes off, sit down at the table and just look. I don't want to think about anything. I don't want to talk about anything. So you telling me after I had to listen to you go on all that long, all right, about nothing. Now I got to sit here with my colleagues for another however many hours so we can think how we can one up you the next day. Kudos to them, right? And I think he cut his signature braids off too. You remember what was that show he had? Pimp My Ride. Did you ever watch that? I loved it. Yes, I hate it. I'll be glad when that goes away. They've been saying that since the 90s though. I don't know if y'all remember that song, but yes, I despise that word.
To review it over the weekend is in some respects because of what the state just said. There's information on that clip, at least from Ms. Patterson, that I didn't know if you wanted to come in or not, about nothing happened here, right? Those types of statements. So that's why I give the parties a chance to look it over and then come back to court and tell me what they want to do. So your position has been made clear. You believe it should be struck or stricken, as we say. And I agree with you, Mr. Brooks. This court gave a very clear prior ruling related to other acts, and the state had an obligation to abide by that ruling. While I have options available to me, meaning I could redact it if the jury wants to hear it later on, my concern with redaction is it may possibly highlight that portion. We don't know whether any one of these jurors heard it and made a note about it. And that's certainly not something I'm going to ask them to reveal. And because of the violation, and even though there's other things going on, even though I could redact, I am going to strike this exhibit and so advise the jury. Last week, I also had indicated I had asked the Sheriff's Department to prepare an incident report regarding one of the occasions Mr. Brooks was removed from the courtroom. I've been advised it's been dictated and I believe written. I haven't seen it yet, but I did follow up on that this morning. I believe I'll have it at some point today, and we'll turn that over to the parties.
To the 6th, Thursday, October 6th.
That was in reference to.
Oh, hold on. Where are we at? I think that's a learned behavior. I really do. I don't think that his hearing is impaired. I think that's just Darrell knows what to do and when to do it. You know, like a child. children learn behaviors. They know what they can do to get away with things to get more attention. You know what I'm saying? Because he didn't do any of that during the preliminary hearing. He didn't he was able to hear music clearly when he was rapping. I've seen videos of him performing on stage. He seemed perfectly fine to me. Um he did not start mentioning that he had difficulties hearing until she removed him to the other courtroom. And I think that was just a way for him to get out of being removed from the courtroom and to possibly get her in trouble. So I don't know. Hello there. How are you? I am sipping on some wine. Yes, I am. Oh. Oh, Tammy! Let me tell you something. Let me tell you something. I have said that many a times, and I've almost gotten cussed out for saying it. So much so, someone was so upset with me saying this that they couldn't even put periods and proper punctuation in their dissertation to me. Okay, I echo your sentiments, but it is what it is. Everybody's entitled to their opinion, but I believe the same things. I believe that had he applied himself, it would be much different for him. But we all have our own opinions. Absolutely, Jeff. Absolutely, absolutely. hmm I would be absolutely exhausted. I would be. hmm He did. What y'all talking about? I told y'all this man got degrees from all of the top schools, law schools in the country, Columbia, Yale, and Harvard. He passed his LSAT on the first try. Okay. He scored what? I think you got to get close to 161 as possible, 172. He did that. Okay. He's presenting an awesome defense. He has the jury ready to rule in his favor. They are ready to do what's right and not kick themselves for their decision. Yes, Debbie. Yes, absolutely. Oh, man. Exactly. Exactly. Tries again to wear her down to the ground. Yes.
The incident where, if my memory is correct, where there was not about the COVID test, but about the needing you to sit down so that I don't remember if you were over there or here or what, but they needed to get those restraints either on or off so that you could be situated. And that's where you had indicated you had been hurt. So that's what I'm talking about. I wanted to have a record of that here.
I think that was the 6th. I also want to state for the record that I was given paperwork to fill out a report of my own, and I stressed that because
How long this
after
gonna take? Because
the
I'm
detectives
tired
came and took the
already.
pictures of my bruises and injuries, I was told that they didn't know when I would actually get the actual filing of the report that they were going to report. So I just went ahead and asked for my own. I filled that out. I don't know if it's been given to the right parties yet.
You're talking about the inmate complaint form to have the either the jail or the sheriff's department review that related to the use of force.
Yeah, it was the top paper was from the sheriff.
All right, you know that that's not my responsibility to address what happened other than how it impacts this trial, which is why I wanted to have a record. If there's anything you believe should be in the record from you regarding that, then you should turn that in.
Okay.
All right, I didn't have anything else on my list of things. I don't know if the state does or Mr. Brooks, so I will ask the state first if there's anything you believe I should address prior to the jury coming back out.
Yes, Your Honor, I would ask that some of the witnesses that testified last week be released from their subpoenas, especially now that we have Mr. Brooks' witness list. Specifically, I'd be referring to Corey Runkle, Officer Phillips, Kyle Edwards, Holly Berg. I note on his list today, he does still have Erica Patterson and Detective Guth. At some point, we'd like to be heard about that, but we don't need to delay the jury at this point.
All right, any position on their request, Mr. Brooks?
I guess my objection to that would be Officer Phillips. That would be one that I would still like to be under subpoena. Everybody else is I'm fine with.
That's the officer whose squad video I just struck. So you didn't have him in your subpoenas. So you'll need to, for now, I'll tell the state they can't release him. You'll need to fill out a subpoena, and I need to have that by the lunch hour today in order for him not to be released from the state subpoena.
And I definitely don't want Erica Patterson released from.
Right, you have her on your subpoena, so I understand that.
I just wanted that for the record.
All right, thank you. All right, then I will grant the request.
So tired of him bullying that poor child. You got a point, Terry. You got a good point. Hey, Kishana. Kids and people that run from accountability love pretending they didn't hear you when you call them out. Yup. Mm-hmm. Oh, Lord. I can only imagine when I pick up my next textbook if there is some mentioning of him. I had to write a paper about a trial that I watched, what my observations were, so on and so forth. And I wrote about this trial. And one of my instructors from the summer is from Wisconsin. And she just couldn't believe it. She said she had never seen anything like it, and it is something that will always stay with her. Um, it is just a mess. That's what I'm saying. I think he's an auditory learner, and so something where if he was able to listen to and recall information, and something where he was able to argue, he would have excelled in that. I believe that. But like you said, I mean, he still would have that little bit of crook in him, but I think just being able to regurgitate information and arguing, I think he does that well. Hey, Shonda, how are you? How was your Sunday? I hope you had a beautiful day today. See what my girl's Kelly saying. The only way I can watch this is knowing he gets 1,000 years, right? Right? My friend, this man who says license place. He said, "Don't worry about that. He don't have to spell it. He got in and he excelled." Okay. Hey, Beverly, how are you? Uh-oh. I think, Beverly, you were one of the ones to disagree with me. Let's see what you're saying, girl. DB is not smart or gifted. He is a con merchant, a pathological liar. Uh-oh. I'm not saying the other word. He does not have one redeeming feature. Okay. Hey, Maya girl, how are you? Right. I think that's what he thinks court is. Like they say something and I have to say something. He's one of those people where he has to say something too. He can't just say, you know, no objection or whatever. He has to disagree. He has to have a point. He has to have something to say because he feels left out. He's not doing his job correctly as a third party intervener if he's not objecting, right? Right, right, right.
From the state as to Corey Runkle. Kyle Edwards and Holly Berg. For now, Officer Phillips will remain under the state subpoena along with Erica Patterson and Detective Guth. We can take issues up with that either, maybe closer to the lunch hour or when we come back, or even at the end of the day. But I would like to bring the jury out. But of course, Mr. Brooks, I need to turn to you first and see if there's any issues you believe the court should address.
Very briefly, I just want to state this for the record that I would like to issue the court an apology
What?
from me in regards to my actions last week during the trial.
Yo, why the cameraman so petty and zooming in on his lies? Look, y'all.
I just want the court to understand it's very emotional right now, not only for just the whole situation of the trial, the families here that have to go through, everything that's going to be involved with the trial, but also my family as well and myself is very, very emotional. But not to excuse my actions, I should carry myself with better respect than that. I wasn't raised that way. And I owe you, Your Honor, and the court an apology. And I'm going to stand up as a man and tell the whole court and you, Your Honor, that I apologize to the bailiffs, that I apologize for my actions. Like I said, that's not how I was raised. I come from a Christian background. My mother did not raise me that way. She did not raise me, to act out of frustration and irritation and anger. And I just wanted everybody to know that I apologize for my actions. And I'm going to try my best. I just wanted y'all to know that.
Okay. Y'all think his bald-headed mama told him to say that? Hey, Melissa. Hey, Melissa. I read your comment to me about that appeal. I want you to know that I'm doing a video on it, and then I want you to watch it and then tell me what you think after that. But thank you so much for coming in. Let's see what you got to say. I am really enjoying your commentaries. I think you are down to earth. I think you're fair, you're interesting, and you keep the dialogue moving along. I started following you when I think you only had 7 or 8 followers. I'm gonna keep coming back, though. You're really interested. Thank you so much. This little channel has grown, y'all. I think we are 729. Melissa, thank you so much. Okay. Listen, if you don't mind, I'm gonna tag you when I do that appeal video. And I want you to watch it, okay? And tell me what you think based on what I came up with. And see how you feel about Judge Darrell explaining herself till she had white mouth. Okay, but thank you so much. I really appreciate you. Lauren, could Judge Darrell deny his right to represent himself once the trial got started and saw how he behaved? Yes, that's what he was trying to press for. So, per the law, if his behavior just became too egregious and that's okay. So, I'm doing a video on Illinois v. Allen. Illinois v. Allen, Michael Allen, his behavior was 10 times worse than Darrell Brooks. And so that's why she kept saying that over and over. So if he got to the point where she just could not control him whatsoever, then absolutely she could have he could have forfeit his right to represent himself, and then that would have been the end of that, and she would have had to appoint counsel, and he would have just had to sit there and be quiet, and she would have had the opportunity to bind and gag him. However, being Judge Darrell and just me observing what type of judge that she is, she didn't want to do that. She wanted to give him the opportunity. Also, it would cause a delay because if she had taken the opportunity away from him to represent himself and having to appoint counsel, it would delay the trial because that counsel would then have to go in and review all of the discovery, potentially have to petition the court for money to get new experts, so on and so forth. So that would have delayed the trial, and she was really, really, really trying to avoid that. But she could have done that, yes. Oh, Dog Mom, thank you. So didn't. I'm telling you, you know what? I think that his mama told him to uh say that because I remember in one of the interviews she had with the news station, she was saying that because the journalist said, your son has been in there. He took off his shirt. He is arguing back and forth with the judge, and she was like, "I know. I talked to him, and I told him he got to stop because he's making himself look bad." So I think he called her, and she was like, "Look, dude, it's only so much I could do to help you, but you're gonna have to stand up there and apologize and get yourself together." That's just me speculating. I don't know. Oh, are you a new nurse? I went to nursing school and then I dropped out. My son got sick. We think he had COVID before we knew that it was a thing. But I don't regret my choice because ultimately I wasn't happy. But I love and respect all nurses. It is not an easy job. Um, Nurses do not get enough credit for what they do, laying your life on the line, your mental health, and your physical well being at times for the sake of saving and healing and helping others. So kudos to you. And I appreciate your service and enjoy your day off until Thursday. Okay. It is well deserved. Yep, she did. Okay. Right after. Oh, God. Oh, she would have had to gag him and place him in a wheelchair. His mind is like the wheel on Wheel of Fortune, except it never stops. Yep, 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 yep. We don't believe him. We need more people. I can only imagine the fit he would have thrown if she would have got him strapped to that wheelchair and something in his mouth. Oh my God. Oh, okay. So which one do you think you like better? I worked in Jerry. I did work in peds, cardiothoracic. Let's see, cardiothoracic, peds, Jerry. Is that it? And Reno, Reno. Yes, we thank her. We appreciate you. Isn't that he a mess? That was hilarious. You can tell his confused face versus his "I'ma argue" face. When he wants to argue, he gets those wrinkles in his forehead. And his eyes get big and he doesn't blink. Hey, you, how are you? My German friend and now lives in California. How are you? All right, let's go back. Excuse me.
Thank you, Mr. Brooks. I do appreciate that. Understandably so. This is an emotional experience, I think, for everyone
All
involved.
right, let's get down.
Um,
I don't want to hear Judge Darrell sing his praises at all. So excuse me while I skip through that because I don't want to hear none of it.
Playing of Exhibit 6. With that, we have Detective Casey here for cross, as is my practice. When there's a second day, someone's on the witness stand, I am going to have him stand to be sworn in again by my clerk.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Thank you. Please be seated. And once again, for the record, state your first and last name.
Thomas Casey.
Thank you. Mr. Brooks, this is your opportunity to question him.
Good morning, Detective.
Good morning.
So, how long have you been in law enforcement?
Know that already.
25 years.
Since a long time. I want to direct you to the evening of November 21st, 2021. You stated that you were on duty that afternoon, correct?
Yes, sir.
Do you recall any disturbances that afternoon?
Do you mean when you drove through the parade routes? And
Uh-oh.
Your question was a little broad. Why don't you try to narrow down the time frame so he can answer that more specifically?
Roughly around the time of.
Why in the world would he ask him that? You know he remembered that. That's not part of a defense. You need to ask questions based off of what the prosecution tried to prove. Why would he ask that man something like that? My Lord. What is this? Awesome. Yep. Yes, because maybe one day we can watch the preliminary hearings together, but his old attorneys tried to ask for a continuance. They didn't want the trial to start until 2023, March of 2023. And Judge Darrell said, no, there's no reason for that. Mm-mm. That could be part of the reason why. I don't know if Darrell didn't want the lawyers anymore, or if the lawyers did not want to represent him anymore. Now, mind you, they were both working on cases right along with Darrell's case. So it could be that because she denied the continuance that they just chose to withdraw, or Darrell could have asked them, or it could have been a joint decision. It could have been a combination of things. I'm not sure. I have to go back and watch that video, but yeah, she's trying to get that on. She was very considerate to the victims, very much so. Ain't no need to draw this out. We got all the evidence. You got the discovery. Um, they did not hire any type of experts to speak on Darrell's behalf. So what are we waiting for? Oh, that's so sweet. Thank you, Miss Shonda, for all your hard work. Hey, ambitious. How are you? They did. Hey, Cindy. I'm pretty sure that when he appeared in court on the genuine charge involving his nephew, he was strapped down. Yes, he did. He looked like he was in a stroller. Right? I think Mushmouth edited that part in there. Um, I can't remember. I don't know if it was this time or when the state called him, because he was the last witness for the state. So I can't remember exactly, but we getting ready to see.
Maybe 4:30ish p.m.
yes, I do.
Do you remember what you can recall?
Do I remember if I can recall?
Do you remember the disturbance you recall?
Yes, I do.
Detective Casey looking at Judge Darrell. She ain't gonna help you because she up there doing something else right now. She done tuned out, clocked out for the day.
Say what that is? What that was, rather?
I heard a horn beeping, and then a Ford Escape came through the parade route, and you drove past me and wouldn't stop, and you continued driving into the parade route.
Who is you?
Darrell Brooks, the defendant, seated at the table.
Let the record reflect that I do not identify by their name, nor do I know anybody by that name.
What's your name? Brooks.
So you heard a horn beeping.
Yes.
Was it coming from the vehicle that you tried to stop?
I believe that it was.
You stated that you've been in law enforcement for 25 years. That's a long time.
Mm-hmm.
So it would be fair to say that you operate a motor vehicle pretty much every day. Would that be fair to say?
Yes, I operate a motor vehicle almost every day.
And would it be also fair to say that you would only beep your horn in a motor vehicle if you were trying to alert someone to your presence?
I think that could be a fair statement.
Okay. Excuse me, y'all. His bald headed mama tore him up. I don't know, but I'm sick of it. Oh, he just can't move away from trying to prove that it's not his fault and it's Erica's fault. He just keeps incriminating himself over and over again because he's a vicious rabbit moron. All of a suddenly. Oh.
Would it be also fair that you would beep your horn to avoid any danger?
There could be
Nobody's questioning if you're in the wrong or right about beeping your horn. In fact, if you did mistakenly drive on a parade route and you were blowing your horn, fine, I'll give you that. I think you were responsible at that time. But what hurt you is when you chose to ignore law enforcement and keep going. So why are we talking about this? It doesn't matter. It doesn't matter. All of that goes out of the window. Okay. When you took your little baby foot in that flip flop and pushed the pedal. So why are you questioning him about that? What difference does it make, Darrell? You blew the horn, but not to get away. Like you blew the horn. I don't know why you blew the horn. Maybe you did blow it because you saw a bunch of people, but it didn't matter anymore. So we could just cross that one off the list with that little pen you got. Don't matter.
many reasons why a person is beeping their horn.
Would one of those reasons be to avoid danger?
It could be, yes.
Do you recall if you were able to see who was operating the vehicle you attempted to stop?
Yes, I was.
And can you recall a description of the
Now you
operator
about to
of the?
get yourself in trouble. You absolutely know he can provide a description. These are the same questions that the prosecution already asked him. They drilled him during the preliminary hearing. You know for a fact he knows who you are. You know for a fact he knows the person that was driving the SUV. This is not a good question. In fact, you didn't even have to cross-examine him because he's not going to help you at all. There's no loopholes in the story. The story has been consistent. He said you drove on the parade route. He ran to your vehicle. He banged on the hood. He saw you. He can positively identify you. He said that you continue to go, side-swiping him with your car, and that is where that ends. He couldn't catch up with you, so he radioed in. There is nothing else to ask him. There's no loopholes in this. Even if he can't identify you, it still doesn't matter because guess what? The key to the car was in your pocket. So even if he can't sit on the stand and say, "Oh, well, I know it was you," don't matter. The prosecution already proved what they needed to prove. So this wouldn't have been somebody that I would have asked anything to. You just digging yourself deeper into a hole at this point, especially with this questioning. You can't go off of what Anna Keys did because even her questioning, in my opinion, didn't make sense. He's proven that he can identify you, and that's where it is. He wasn't. He did. You think he traveled along the whole parade route with you? No. This is the same thing like with Detective Carpenter. Like you just want to make him miserable because you're upset. He's working closely with the state. He put the pieces of the puzzle together, and that pisses you off because you can't call state of Wisconsin to the stand. So I'm gonna say it again. He and Detective Carpenter was as close as he could get to questioning the state because he knew that they worked directly with the state. And so now I'm gonna make you miserable up here. That's all this is. Like you don't have any questioning that will help you, sir.
the vehicle you attempted to stop?
He was light skinned, black male, had some light facial hair.
Is that all
There's
you
no
recall?
way I would ask a detective to identify me. No way whatsoever. Mm-mm.
That is what I recall.
Do you recall what they were wearing?
No, I do not.
So you were able to get a
Now,
description of
with this question, he's trying to see. Excuse me. Oh, I drank that wine. I guess he's trying to see if Detective Casey is lying because if you remember when the state questioned him, he did identify what Darrell had on. He said a lighter hoodie, and they showed a picture, and he said, "Yeah, that's the hoodie that he had on, and I think a shirt underneath." Now he's saying that he doesn't recall what Darrell had on. Still, I wouldn't have asked him to identify me, but I just made that quick observation. But I don't know where he's going with this.
how the operator of the vehicle looked, but not what they were wearing.
That is correct.
Do you recall how fast?
Okay, hold on. Let me catch up on these comments. He kept going, y'all. Excuse me. Excuse me. Thank you so much. Y'all run my likes up, please, please. I don't ask y'all for much. Also, I do want to thank the new member that we have. I don't know if you guys know I am offering memberships if you guys want to join or not. I know it's the holidays. You don't have to, but with my membership, I want to offer an opportunity for us to analyze 2 cases a month as honorary paralegals. And we can dissect those cases with the case law that I provide, and so on and so forth. But it's up to you guys, of course. I'm not trying to pressure or look horse you to do anything, but I do want to thank the new member that I have. Thank you so much. I know that he had no idea. He didn't have to cross-examine everyone. Exactly. Excuse me. Well, he should have asked his co-counsel, his bald-headed mama. I can't take it. Child. Oh, thank you so much for your service. We got another nurse. Thank you so much. He did. He did. He said, Detective Casey, even though you got 25 years, you still a rookie. It ain't me. You can't even identify the article of clothing that I had on. All right. Oh, I did step down too. Step down and telly. I forgot about that. Those telemonitors, telemetry, Q6-hour blood sugars. Yes, ma'am. Yes. All right. Let's get back to it.
The vehicle was going at the time you attempted to stop it?
I believe the vehicle was going about 3 to 5 miles an hour when I tried to stop the vehicle, and it continued on past me.
Would it be fair to say that 3 to 5 miles an hour is not very fast?
I think it's very fast when you're in a parade route, when there's hundreds of people marching in the road and a police officer is standing in front of your car, pounding on the hood, trying to get the vehicle to stop. I'd say that that's too fast. Any speed is too fast on a parade route when you have all those people in the roadway. The car should not have been there.
That wasn't the question, but thanks for the commentary.
That was the question. That was the question. What do you mean? I need to run the record back a little bit because I ain't even hear that good. Hold on.
I think it's very fast when you're in a parade route, when there's hundreds of people marching in the road and a police officer is standing in front of your car, pounding on the hood, trying to get the vehicle to stop. I'd say that that's too fast. Any speed is too fast on a parade route when you have all those people in the roadway. The car should not have been there.
That wasn't the question, but thanks for the commentary.
Detective Casey, please just answer his questions. Attorney Acker will have an opportunity to redirect if necessary.
Oh, so she teams Darrell today. Okay.
Would it be fair to say that that's not a very fast speed?
objection asked and answered.
Mm.
Sustained.
Do you recall if the operator of the vehicle that you gave a description of had any hair on her head?
I do not recall seeing the operator's hair that day.
So it would be fair to say you don't know if they had long hair, short hair, anything of that nature?
That is correct.
Now wait a minute. Didn't he say when he was being questioned by the prosecution that he remembers seeing some hair? Am I tripping? No. Hey, Jason. Y'all are so funny. Right. He can't get under his skin, so he's pissed. Oh, that's right. You did. How was your concert? Oh, she's probably gone. We'll talk about it later. I forgot you had the concert today. Oh. Good night, Debbie. Get a good night's rest. Okay, Melissa, let's see. I think he has a fantasy life like he's Superman and he's smart and clever and he's irresistible to women. How horrible it must be for a man and wakes up in the morning and looks at that face. Ugh, and them chiclet teeth. Jesus. He said he didn't recall the hair, but he definitely said he did. Do I need to run the record back? Because I thought I heard him say he has some hair. Now, you know what? I'll tell you where he said that. He said that at the preliminary hearing. I'm telling you, he said that. And it ain't me being on Darrell's side. I heard him say he saw some hair. I'm going to have to look into that again. Hey, Alex. He pulls that wasn't the question a few times. He does it with Detective Casey in his second testimony when asking about his mom reefage. We getting ready to watch that in a few minutes. All right.
Do you recall testifying at the preliminary hearing in this matter?
Uh-oh.
Yes, I do.
See, I told y'all. Oh, I almost choked on my wine. I told y'all, watch this.
Can you recall what you said when asked a description of the driver of the vehicle you attempted to stop?
I don't recall word for word what I said.
Mm-mm.
Do you recall being asked the question?
I would think that I was, but I don't recall the exact words that I used then.
Just 1 second.
Uh-oh.
Do you
Darrell
recall?
said he got receipts. He came prepared that he ain't playing with none of y'all today. He got receipts.
Saying that the operator of the vehicle you attempted to stop had short hair and a short dark beard?
I'm not sure what the context is, but I don't recall saying that the person had short hair.
The context was the question of, did you get a description of the driver of the vehicle you attempted to stop?
I guess I'm not sure when you're speaking of, because was that when I saw the car or when we saw the vehicle after what witnesses said? It seems like I'm not sure exactly the time period.
So are we talking about what witnesses said or what you actually saw?
Correct. That's what I'm confused about.
Well, you just said that you recall being asked at the preliminary hearing that you testified at a description of the operator of the motor vehicle. Would that be fair to say?
I don't understand your question.
I think it's very clear. You testified at the preliminary hearing in this matter, correct?
Yes, I did.
And were you not asked a description of the operator of the motor vehicle that you attempted to stop?
So I believe my testimony was at the preliminary hearing that I did not see the person's hair, if that's the specific time that you're speaking of.
I have a portion of that preliminary hearing that you testified at with your words right here.
Mr. Brooks, what page are you at?
I am at page 17.
All right, thank you.
You were asked could you see anybody inside the vehicle? Your answer was, at that point, I could not see the person real clearly, but as the vehicle continued pushing through me, I was paused. My position changed to the side of the vehicle where I was directly outside the driver's side window. And I could see inside of the window and I could see the driver very clearly. Would that be fair to say that those are your statements?
Yes, sir.
So could you or could you not see the driver clearly?
Your question is if I could see him clearly. Yes, I could see him clearly.
So why would you state that you couldn't see him clearly when asked the question?
I think you're asking about his hair.
No, I asked
going
about
back
his
and
hair
forth
before.
between.
This is a different question.
Detective Case need to quit looking at Judge Darrell because she is team Darrell today. Darrell think this is his mic drop moment. Do y'all hear me? He done pulled out them receipts. Oh no, I hope you're doing better. Not a broken leg. I'm so sorry to hear that. I'm gonna play it for y'all. I gotta look on my little calendar. Let me write it down. It's like 4 or 5 of them. Preliminary hearing. We can watch them together. Okay. I done wrote it down. Okay. Excuse me. They are. Oh, I can't breathe. Oh, Jesus. He ain't playing with y'all today. Darrell thinks this is his mic drop moment. He is trying to impeach Detective Casey, but what he fails to realize is that this is not going to work. It doesn't matter what he says at the preliminary hearing. We're beyond that part, buddy. You can't use that against him. I applaud your effort, though. I do.
Could you ask your question again, please?
You just stated that you could see the driver clearly, correct?
Correct.
But you also said that you couldn't see the driver clearly, correct?
Objection, that's a mistake.
Grounds.
Oh!
So, Mr. Brooks, I think it comes down
Wait
to
a minute,
context and the system.
So why would you state that you couldn't see him clearly when asked the question?
I think you're asking about his hair.
No, I asked
going
about
back
his
and
hair
forth
before.
between.
This is a different question.
Could you ask your question again, please?
You just stated that you could see the driver clearly, correct?
Correct.
But you also said that you couldn't see the driver clearly, correct?
Objection, that's a mistake.
Grounds.
Oh!
So, Mr. Brooks, I think it comes down to a little bit of context. I'm going to sustain the objection. And then if you would please rephrase. I think it comes down to at what point in time in the contact with
Why
the
is she being so gentle with him? Lord, I'm sick of it.
SUV are you referring?
At any time.
No, we need the question again. That question is vague.
Right. Put it all together. If you would, I'll sustain the objection.
At any time, could you see the driver clearly? At any time during your attempt to stop the vehicle?
Yes, at any time I could see the person clearly that was driving.
Okay.
The entire time you attempted to stop it, you can clearly see the driver of the vehicle.
Well, at one time you asked any time, and then you asked the entire time. So
Detective Casey, just answer the question, please, if you can. If not, say you don't understand it.
I don't understand it.
Just a second.
Okay.
Did you observe the vehicle strike anyone when you attempted to stop it?
No, I did not.
Did you see the vehicle strike anybody before it approached you?
No, I did not.
Would it be fair to say that there were hundreds of people present at the time that you attempted to stop the vehicle?
Yes, there were hundreds of people there.
And you saw no one struck by the vehicle?
That is correct.
Did you see if anyone else was, could you see rather, if anyone else was in the vehicle?
I did not see anybody else in the vehicle when it passed my location.
Do you recall there being any tinted windows to the vehicle you attempted to stop?
I do not recall the passenger front or the passenger rear being tinted. I believe that the rear windows in the SUV were tinted.
So it would be fair to say that from your vantage point, you wouldn't be able to see the entire seating of the vehicle you attempted to stop?
Objection as a statement.
Grounds.
Overruled. You may answer the question.
Could you re-ask the question, please?
Would it be fair to say that because of the tint to the rear windows that you could not visibly see the seating of the vehicle that you attempted to stop?
I did not see anybody in the vehicle. I don't think that the tint had any reasons for me not to be able to see in.
So it would be fair to say that you could clearly see the seating of the vehicle you attempted to stop, front, passenger, and back seat.
From the limited view that I had, I thought that I could see it.
Even though you just said that the rears were tinted.
I believe that it's the far back windows in the passenger compartment that were tinted, not the passenger windows, from my memory.
So it'd be fair to say you can recall every window that was tinted on the vehicle that you attempted to stop.
I think that question's been asked and answered, Your
Grounds.
Honor. His answer should
Grounds.
stand.
Hold on, Mr. Brooks. The objection is sustained. Next question.
Detective Casey, are you a party to this case in any way?
I don't understand the question.
Are you a party to this case?
I don't understand the question.
Have you filed a claim in regards to this
Oh,
case?
here we go.
I have not.
Have you read the complaint in this case?
Of course.
I've read the complaint.
Do you recall who the complaint was brought by?
The complaint is brought by the state of Wisconsin, represented by the Waukesha County District Attorney's Office, District Attorney Sue Opper.
So the state of Wisconsin then would be the plaintiff in this matter then, correct?
That is correct, the state of Wisconsin.
Do you see the state of Wisconsin present in the courtroom right now?
Yes, I do. They are represented at the prosecution table by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Witchell.
You said represented.
Yes, sir.
Do you see the plaintiff?
The plaintiff is an entity. They're represented by the District Attorney's office.
So the plaintiff is an entity.
Correct.
To the best of your knowledge, is an entity a human being?
An entity is an entity, it is not a human being.
To the best of your knowledge, being in law enforcement for as long as you have, would it be fair to say that an entity, which is not a human being, living person, can bring a claim against anyone?
I believe they,
Object, Your Honor, to the
Grounds.
relevance.
Grounds.
Objection out, okay?
I mean, I've tried to be patient, but these questions really have no bearing on this.
The objection is sustained on relevance grounds. Next question.
Have you ever had any interaction with the plaintiff in this matter?
Objection, irrelevant.
Grounds.
Sustained.
How long have you known the plaintiff in this matter?
Objection.
Grounds.
Let her get her objection out, Mr. Brooks. It's sustained on relevance grounds.
Well, I do respect, Your Honor. I think that those are valid questions to the matter.
Mr. Brooks, they've been sustained. Next question.
Just so we're clear for the record, you did hear the vehicle that you attempt to stop blow numerous times, blow its horn.
yes, I heard the horn blowing as it was approaching my position.
Would it be fair to say that that would indicate that the vehicle was trying to alert people to its presence?
Objection calls for speculation.
Grounds.
Sustained. Speculation.
So would it be fair to say that the beeping of the horn was coming from the vehicle that you attempted to stop?
Objection asked and answered.
Grounds.
It has been asked and answered. One last time, he may answer though. Go ahead. The objection's overruled.
I believe that it was coming from the vehicle that was coming to my position, the Ford Escape.
I want to refer you again to page 15. It is from your testimony at the preliminary hearing.
With Your Honor, that's improper because Detective Casey does not have the testimony transcript in front of him.
The district attorney is correct. This witness does not have the transcript in front of him.
So would that render him unable to recall what he testified to?
I don't know. You have to ask him that.
That's what I was attempting to do.
Shut up.
So just so I'm clear, am I allowed to read from this or no?
Just ask your question, Mr. Brooks.
From the best of your knowledge, do you recall stating in your testimony at the preliminary hearing that it was in fact the vehicle you attempted to stop that was blaring its horn?
Objection, that's not what the
Grounds.
transcript says,
Grounds?
and it's been asked and answered.
Sustained.
Were you injured in any way attempting to stop the vehicle?
I was not injured when I was trying to stop the vehicle.
What did you do after attempting to stop the vehicle?
I first got on my radio and advised the other units that were in the parade route that red Ford Escape had went past my position. I requested additional squads be sent 1039, which means red lights and siren. Shortly after that, I began running after the Ford Escape in an attempt to stop it, but the vehicle sped up to a speed that I couldn't keep up with it until it hit the next position.
Reading from the transcript, page 18, do you recall us making a statement? Initially, I began, it's sort of what you just said. Initially, I began chasing after the vehicle to try to get it to stop. And as I was following behind the vehicle, I could see that it was on the north side of the roadway, at times beeping its horn. Would that be fair to say that you made that statement?
That is a fair statement.
So even after you attempted to stop the vehicle, you still observed the vehicle beeping its horn?
I heard the vehicle beeping its horn after it passed me.
No further questions, Your Honor.
Any redirect?
Yes, just briefly. I'd like permission to put up Exhibit 120 again, Your Honor. It's already been admitted and published.
Permission granted.
You've been asked here today several questions from Mr. Brooks about what you saw as the vehicle passed you. Is that correct?
Objection. I do not consent to being called that name, and I do not know the person that you refer to.
What is your name? Brooks. Darrell.
Yes.
Is Exhibit 120, well, strike that. Do you know where on the parade route the vehicle was located when this screenshot was captured?
Objection, hearsay.
Overruled.
Yes, I do.
Where?
Approximately the 200 block of West Main Street. The building directly opposite the Ford Escape is 234 West Main Street.
You were back at the intersection of White Rock and Main Street, correct?
Yes, I was.
So about how far was it from where you saw the red SUV with Mr. Brooks driving to where this photo was, where this video was taken, and this is a screenshot from that video, correct?
Objection. I do not consent to being called that name, and I do not know the individual by who you refer to.
What is your name? Brooks. Darrell.
May I answer the question?
I would say that it's approximately 0.2 of a mile for me, a very short distance.
Okay. Was the appearance virtually the same from when you saw it to when this screenshot was captured?
Objection, hearsay.
Overruled.
Yes, it was.
Are you able to see the driver of the vehicle in this screenshot, sir?
Objection, hearsay.
Overruled.
Yes, I am.
Can you see the hair of the driver in this screenshot, sir?
You cannot see his hair.
As the vehicle went past you back at your post on White Rock and Main, what were you focused on?
I was focused on the driver's face when it was driving past me.
Okay. You told us on direct examination on Friday you were able to pound on the hood, correct? Were you directly in front of the vehicle at that point?
Objection. It was also, he also said in his testimony on Friday that he can identify the clothing. He specifically said what the color of the
Mr. Roach,
clothing
you're attempting to
was.
testify. That's not a proper objection. As to the specific objection, it's overruled, and Attorney Opper may complete her question.
Where were you positioned when you were pounding on the hood of the SUV?
Objection.
Overruled.
And by that, I don't mean the street, I mean where on the car.
I was directly in front of the vehicle by the left front bumper.
Did you have to step out of the way to avoid being struck?
Objection. Hearsay.
Overruled.
The vehicle came in contact with me. As it was pushing through me, I shuffled my feet to the side, and then I continued down the side of the vehicle where I came directly in view with the driver's side window.
Okay, so you would have been, what was the driver doing as it passed you?
Objection. Irrelevant.
As he passed you, I should say.
Overruled.
Objection. I do not consent to being called he.
Initially, he was staring straight ahead, and as I was pounding on the driver's side window, he turned and looked directly at my face.
Okay. The reason you were pounding on the hood and pounding on the driver's side window is what?
I was trying to get the vehicle to stop.
Did the vehicle stop?
The vehicle never stopped.
Did the driver make any effort to pull over or pull off the parade route at that stop?
Objection. Hearsay.
Overruled.
I initially chased after the vehicle, trying to get it to stop. I could see the vehicle driving until it crossed Barstow, where it first made contact with people. The vehicle sped up, and I never saw it slow down or stop until I lost view of it as it crossed Barstow Street.
Okay. Okay, thank you, sir.
What y'all over here talking about? I have never seen anybody argue. I have ever seen. What you talking about? It's just too much to even comprehend. I just don't understand them. Yes, for sure. Right. I'm telling you, he just knew it was going to be a mic drop moment. We understand. He's a third party intervener. He did. Oh God. Yeah. None. What's a lie? What he lie about? Oh, I never watched that trial. Was it crazy? Listen, let me tell you something. Dog Mom and I agree. I believe Dog Mom is a paralegal herself. And her being very gentle with him and over explaining everything won't make or break that appeal. It won't. You know what I'm wondering is if someone heard that, like if one person, you know how one person can say something and everybody just runs with it. I'm wondering who said that and why everybody chose. And I'm not saying you did, Monica, but I'm just saying everybody chose to run with that. Because every time someone says, "Oh, we don't agree with Judge Darrell being, very careful with him and over explaining things and allowing him to go as far as he did with his antics in the courtroom," everybody comes back and says, "Oh, she had to do that so that he won't get an appeal." No, that has nothing to do with that. It has nothing to do with that. It really doesn't. And I can't wait to do this video. But I'm just wondering who put that out there and then everybody's just running with it. Absolutely. Hey Glenn. Glenn, are you from Auntie Miracle's channel? I think I've seen your name somewhere before. But hello, how are you? Good to see you. Oh, being on the front of the vehicle. So, hold on. Was that video where I kept replaying and I said that I didn't see him hit the vehicle? Remember that? And I kept replaying it, but unfortunately, we couldn't figure out if he actually made it over there in time to hit the vehicle. I'm telling y'all, I didn't see that. Excuse me. And I slowed it down. We tried to zoom in and I watched from where his position was on the street and how fast the car was traveling. I don't believe that he hit the front of that car. Maybe he was able to kinda touch the sides of it to say, "Hey, what you doing?" But I don't believe he pounded on the front of that hood. There is no way that you pounded on the front of that hood and then was successfully able to get out of the way if you're saying that the car kept going. He didn't run you over, you didn't fall back, you're not injured. I question that too, Shonda, I really do. Yeah. I thought so. Okay, so what is your take about her being overly gracious to him and over explaining things? Now, I know sometimes with new lawyers, sometimes the judge will have to kind of guide them toward questioning, like if they're asking open-ended questions or if they don't understand certain things as it relates to maybe cross-examination and things of that nature. Do you feel, and this is just my opinion about how I feel about the appeal, of course I'm going to do research, but do you feel as a 2L that her over explaining things to him and being as gentle as she was and as patient as she was, do you feel that that would have a positive effect as it relates to him appealing his sentence or appealing his conviction, I should say, or no bearing at all? I'd like to hear from a 2L. He was near it, but I don't think he was not in front of it. I don't think he made it over there in enough time to hit the hood of the car. I don't think that. I don't know. Imma watch it again. We can watch it again if y'all want to, but I don't know. I didn't see that. That too. Let me find the other video. Hopefully Glenn can give us his insight as it relates to that, and hopefully he doesn't mind. I didn't mean to put you on the spot if I did, but it's just good to have a different, perspective from someone else who is, learning about the law. Let me see. Where is this other video? I think it's day 11 on here. We got day 11. Oh, this is it? Oh, wait, let me find it, let me find it. He's crying, y'all, because he just gave his opening statement, and Judge Darrell was like, "Do you need a minute? Do you need a minute?" And he's like, "Yes." Okay, let me see what Glenn said. Hold on. I know it's a lot to type, and I apologize. I believe it was annoying that she explained so much to him, but I do feel close the door on a merit. Oh, wait a minute now. I'm drinking wine. Meritorious appeal. Okay, because I feel that if anyone's case was prejudiced, it was the state, not his. Okay. It's okay. You don't have to type out a whole lot. I was just wondering. Sometimes it's just good to, you know, um, have a different perspective. Let's see. No attorney would ever be able to get up in a courtroom and argue jury nullification. Yeah, we talked about that last night. We talked about that last night. So I don't know. I'm gonna do a little bit more research and see what I can learn and find out about that. And maybe I'm not gonna tell you. There is a lawyer on YouTube that has a channel, a female lawyer, and I'm pretty sure you guys have watched her channel before. And I interviewed her for class, and I am going to reach back out to her to see if maybe she can come over and chit chat with us one evening and see what she thinks. She covered the Darrell Brooks case as well, just a couple days, but we'll see. So let me see if I think I found, let me see what he said, Jeff. I can't wrap my mind around the fact of even why he even went to trial. Why he chose to go to trial? Because a lot of see, listen, most criminals when it starts with interrogation, right? That's why a lot of criminals don't ask for a lawyer because in their minds they feel like if I ask for a lawyer, it means that I'm guilty. So they feel like it's easier for me to try to plead my case with this detective. Maybe, I can manipulate them or over explain, the situation to where they'll believe me. And so it started with that, and then again, most people are not gonna take a plea because they feel like it's a cop out, and you gotta remember how Darrell is, he's been able to successfully get away, and so he felt like, "Okay, I can get myself out of this, with the help of my mom and whoever else, I can get out of this. So, no, I'm not taking a plea because if I take a plea, it's I have to admit guilt, and most people aren't, wanting to do that. Because they feel it makes them look guilty. I have to admit to what I did. He's never going to admit to that. It doesn't matter what happens. He's never going to be remorseful and he's never going to admit guilt. Period. You love Detective Casey? Let me see where I'm at. Okay, let's see what Glenn said. I also want to point out everybody says Brooks didn't testify at trial. Yes, he did. He absolutely did. We went over that last night. Yep. And in a way, like I feel like I don't want to say that it was smart. But like I said, he knew that when he got up on a stand, like he would just provide a narrative, but they could question him. He does not want to answer to anybody, especially given the fact that he thinks that, okay, well, since I'm playing lawyer, I'm equal to the state. I can't question them, so they're not going to question me. So you're absolutely right. He testified, and I wonder, did he realize that that's what he was doing? You know what I mean? Do you think that he realized that's what he was doing at that time? Admitting everything to you. I'm telling you it's not intentional. I'm not saying I didn't do it. I'm saying it's not intentional. I'm saying I panicked. I said that I blew the horn, you know, all of those things that were proven, right? What that mean, Shonda? Let's see what Keyshawn saying. I think Detective Casey did try to stop the vehicle, but because he came across as being facetious during I can't read during at cross examinate, he seemed biased. You forgot your P. Biased. Are just trying to secure the conviction. Okay, just doesn't make any sense. I guess the Lord. Look, I'm drinking, y'all. So if my words get to slurring, y'all know, just forgive me, okay? Okay, and no, she did not have to do half the things that she did, and she did not have to treat him with kid gloves for anything to have regards to do with appellate court. I agree. I do. Hey, Jan. Okay, let's see what Glenn's saying. Anyone who is potentially facing life in prison would be stupid not to go to trial. Many things can happen at trial, but you just never. Yeah, but see the thing. Well, hmm, I got to think about that some more. That's a good point, but I got to think about it some more. So, Glenn, what is your take on him? And I'm sorry, I keep putting you on the spot, but I'm happy that you're here. What is your take on him um, asking his lawyers to withdraw? And with that, what do you think his defense was, if any? Because you do make a valid point. Anything could happen. But of course, he didn't know that he could ask for a dismissal after the prosecution rested their case. Of course, he wouldn't know that he's not a lawyer. So, what do you think his defense was? Just to try to say everybody is a lie, or what? It's mind-boggling, Jeff. Mind-boggling. Okay, he never gave up any potential defense in his closing. He used all of the roles while trying not to admit anything. He would never refer to himself. Exactly. He would never refer to himself as a driver. He never acknowledged a car either. Not specifically. What if the driver of the car couldn't stop? I know when he was doing a lot of questioning, like he would say, the vehicle that you mentioned or something like that, he would never fully acknowledge like red SUV. You think that's why she lost? Now, I read something about her son had some drugs or something. This is allegedly, Judge Darrell, so don't come for me, but I read somewhere from a reporter that your son had some drugs and you knew about it. And that's why you didn't win. But I don't know. I ain't here to gossip about it. That's just what I read. But the bear case, but see, the thing is, that's what I keep saying. But it's barricade, sure. But I would rather get arrested for having Mary Jane in my system and I'm driving than what he did. But see, either way, he would have been he would have been in trouble, but not as in much trouble as he is now because he was driving without a license. He was driving without insurance. He was on probation. He did violate his no contact order, and he did have Mary Jane in his system. But still, like I said, I don't think that the police didn't have time to arrest him. They're working a parade, so he couldn't have thought that. Y'all think that? Yes. Wait, and don't forget, get him to use God against them. God wants you to forgive me. We don't know why God allowed this to happen, but y'all got to forgive me because you love the Lord, right? Okay, let's see. In my opinion, him waiving his attorneys was twofold. One, he knew he was guilty and he knew that his attorneys couldn't help him. True. He figures a side sip crap would help him get a mistrial. Two, he wanted to cross area Erica. True. 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 Okay. I'm not gonna tell you, dog mom. I'm not gonna tell you who it is. It's gonna be a surprise. Let me find this. Where is Detective Casey at? Hold on. That's Nicholas Kirby. I don't wanna. Lord, I gotta find it. Hold on. He's still crying after this closing argument. Oh, there go Detective Casey. This is right before he gives his opening his opening statement. All right.
All rise. Thank you, everyone. Please be seated, and good morning, ladies and gentlemen of the jury. I know it's a little chilly in here. I'm not sure if that will change now that we're all in here. If at any time that temperature is too cold for you, let me know and we can have that adjusted. All right, Attorney Opera, you may call your next witness.
Thank you, Your Honor. The state would recall Detective Tom Casey.
But you know what I'm wondering? Seeing as though the car was never impounded for evidence when he ran over Erica the first time, I wonder if there could be a civil lawsuit against the city of Milwaukee. What y'all think? I'm wondering why didn't they impound that car? Especially, I feel like he was driving without a license and no insurance at that time as well. And so why wouldn't they, unless his mom came and get it, but wouldn't that be considered evidence? I need to look that up.
Yes.
Thank you, sir. Please have a seat. Please state your first and last names for the record.
Thomas Casey.
Thank you. Go ahead, Attorney Opera.
Thank you. Detective Casey, I'd like to begin by asking you to refer
hold
to the
on.
item behind.
Let me see what Glenn's talking about. Also, let's put something out there about Darrell. He has no ability to read the room. He legit believes he could sway the jury in his favor. He did with all that crying and whatnot. Crazy, right? It's crazy. But see that but you zigzag into people. From what I saw, he zigzagged a little bit and then just went in a straight line and just said F it and kept going. I don't know. Right? This the rap video, Maya. See, I brought that up on Ultimate Miracle B channel, how he was able to access the vehicle after. So do we know? Am I right? Shouldn't they have impounded that car for evidence, especially given the fact that, like I said, he didn't have insurance, he didn't have a license, and he used that car as a weapon, right? I just don't understand how he was able to have the car back. Even if it was in his mom's name, I don't know why they wouldn't keep it and process that as evidence. Also need Dawn to explain how she got the car. I need to know that too. How she got the car and no insurance, because before you leave a lot, you have to have proof of insurance. You have to have your license and the title to get tags. I don't know how she got it. We all have wondered that, and I haven't gotten an answer. It does. Okay. So do you think that the citizens of Waukesha who were injured by the car, can they file would it be a claim or a lawsuit against Milwaukee? And what would that be? Would it be negligence? That would be in Nevada, but from my understanding, they're not going to do anything with him with that. There was an active warrant because he failed to register, but I haven't seen anything updated about what they're going to do as a result of that. And they let that go on too long too. And I said in a video before, I feel like they need to reform that, because I feel like anybody, if you are arrested, charged, and you serve time as a SCX offender, before you are released, make them register right then and there. I wouldn't give them the opportunity to go home and just remind them, oh, don't forget you got to register. They're not going to do it. They're not going to do it, you know? So, and then I'm also wondering, someone who is an SCX offender, let's say you're an SCX offender and you have minor children, what role does that play? Like, are you allowed to go back and be a mother or father to your children? Or are you not allowed to be around those children anymore? Y'all bring up some valid questions. I love the way y'all think. I do. Did they pick him up in a car, or was that when they went to the house and arrested him? They probably did go to the house and arrest him, but still, if Erica gave a report saying that he ran her over and they go to question him, and Erica is allowed to give a description of the vehicle and they find that vehicle, I would think that they would collect that as evidence. That's just like if you take a GUN and go on the street and pop somebody and then you run back in the house and put it away. Well, the police will look for it, right? What's the difference? That's just my thought process. Oh. But you can do that without a license? Because even the way that insurance companies are now, once you type in, you can just type in your first and last name and your address, and it's going to populate everybody that lives in that house, right? Excuse me. And ask about who's insured and who's not insured. I don't know. You make a good point, but I just don't know. I'm not well versed as in insurance, so I'm not sure. Hey, Debbie. Right. That's what we're trying to figure out. What's a good idea? I'm drinking too, and I'm behind on these comments. He's not going to. He's not remorseful. He's never going to talk about the case probably anymore. It's behind him. He's not going to apologize. He's not going to acknowledge any of it whatsoever. Whatsoever. It's okay. I got my wine too, girl. Hey, my beautiful friend from South Africa. I so appreciate you being here. What time is it? Is it 6 in the morning again? I appreciate you for being here. Yes, you gotta wait. You gotta wait. You gotta wait. Y'all know I got a lot of ideas for this channel, but I can't tell y'all everything. I did put up a long list on my community tab if anybody has had the chance to look over it and see if it's any cases that you uh are interested in, or if you have a case in mind that I have not added to the list, you can add in the comments. So yeah, I got a lot planned. Yes, he's at peace and it's not lost on him. Y'all ain't about to make this man feel bad. It ain't lost on him. None of that. Oh, do you have to go to work today? All right, let's get back to a little bit of this.
Behind you, there's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
It's exhibit number 15.
Thank you. And we've had testimony about this exhibit throughout the trial. Is that right, sir?
Yes, we have.
All right. Your role in this case was what, sir?
Objection leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
Were you the individual who created this map, State's Exhibit number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection leading.
Overruled. Foundational. The witness may answer.
So at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection leading.
Overruled. You may answer.
So initially that night, we knew that the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital. Waukesha Memorial Hospital received the most patients, so they also had a lieutenant that was assigned there as a team leader. As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
And then eventually, were there follow-up interviews conducted with these individuals?
Yes, there were.
What if the individual was a person under the age of 18?
Objection leading.
Overruled. You may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents. Some of the kids weren't able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection speculative.
No, I do not.
Hold on. There's been an objection. It's overruled. And the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt. We had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately, I learned later on there's even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged are on the map.
So you mentioned people on the sidewalk. We did have some spectators testify in the trial, correct?
Objection leading.
Overruled. Foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk, or not running away from the incident when it happened.
I see. So was, in your mind, when you were leading this investigation, trying to identify victims, what was the importance of the SUV in the injuries that were caused?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
If a person were injured because they were trampled by the crowd, are they on this map?
We exclude those.
Overruled. The detective may answer.
Those people were excluded from the map.
There were some people like that, right?
Yes, they were.
Please make
Sorry.
sure. Thank you. I'll allow his answer to stand. Next question.
All right. I'd like to put up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
Just to the witness or published because it's been received.
Yes, we are going to publish this, Your Honor.
Go ahead.
Objection.
Permission granted.
Detective Casey, I want to focus your attention specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
Overruled. It's foundational. The answer may stand.
Do you know if there were other people associated with the extreme dance team that were injured?
Objection speculative.
Overruled. He may answer.
Yes, I do.
And do you know the names of these people?
Objection. Hearsay.
Overruled. He may answer.
Yes, I do.
What were their names, please?
Kathleen Pellmeyer.
Speculation.
Overruled. He may answer.
Sir.
Kathleen Pellmeyer, Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
Oh, I love Detective Casey. Hey, Eva, how are you? Glenn, are you still here? I know you like, girl, quit calling me, quit asking me stuff. I am going to do another video about Don Woods and all of the possible things that she could have been charged with. So I have aiding and abetting, lying to the police, accessory after the fact, obstruction. What is the law in Wisconsin for allowing someone to drive your car without a license? Possibly evidence tampering. Do you have anything else that you think she could have potentially been charged with, even though none of those things are going to work? I know a lot of us feel, or a lot of people feel, that she should be held criminally responsible. Um, and a lot of people have said those are the reasons why, even though I looked up the law, I looked up the elements to a lot of them, and they don't apply. But is there anything else that you think that they could have charged her with? I don't think he knows why it happened. I don't even think that there's a reason, you know. Um, to be honest with you, I think in the beginning, as he was trying to get away because he was afraid that the police was on the way after he jumped on Erica, he probably did panic and then turned on the wrong street, not knowing where he was. But then after that, I don't think there will ever be a legitimate reason, you know. He just did something. He just he just made a decision to do what he did without it being a reason why. There will never be one. Oh no, speak freely. Speak freely. We do that over here. What you mean? Good night, dog mom saying. I don't think it's worth it ever. I mean, a lot of people, honestly, to be honest with you, Glenn, I think a lot of people are just so upset that this happened, and they just feel like, had she not given him that car, it would not have happened. Um, I kind of feel that way, but I kind of don't, because given the fact that Darrell is a career criminal, something else could have happened either way. I think his crimes would have just escalated until something terrible happened either way. It's unfortunate that this happened. Um, but like I said, those are the things that I came up with, and I think someone else came up with the line to the police, which I told them it wouldn't work because there's no way to prove that she lied about anything. Um, you know what I mean? So she can say all day, well, he stole my car. He can say I didn't steal the car. She gave me full access to it. How do you prove that? So I know someone told me that some of the victims were able to sue their insurance company and they were successful at that. But yeah. Oh, thank you, Hershop. So the question that we have is, how was Dawn able to purchase a vehicle? Because we all know when you purchase a vehicle, you have to either already have had insurance or you have to, get insurance before they let you drive off the lot. So that's the first question. Um, and how was she able to get the tags to the car? You have to have the title, proof of insurance, and a license. She did not have insurance or a license, and Zarel didn't either. And from my understanding, the car is or was in her name. So, how was she able to successfully do that? But who's to say that it's false? How would you prove that it's false? My husband can take the keys to my car and drive off right now, and it can be his word against mine. He can say, "Well, she gave me permission to use the car," and I can say, "No, I didn't. He took it." Who's lying? This is just from a legal standpoint. How do you prove that the person is lying? How do you prove who is lying? Oh, I was wondering. I just let it slip on past, girl. I wasn't gonna judge you. Oh, we all in here sipping. All right. In my opinion, he got into a fit of rage and he blacked out. He's the type of person that when they're angry, they black out and do stuff impulsively. I do agree he will never be able to give an answer right. And I know a couple other people said that too, like they think that he blacked out. But see, when did the blackout occur though? Because to me, if you look at the video in front of the school, like he sped off, right? And the witnesses said that he sped down the wrong way and he was agitated that it was the wrong way. But then when he got on the parade route, he slowed down for that little bit of time. So when did the blackout end? So did it start, while you were jumping on Erica and you got so upset because she had someone to fight for her, and then you sped off trying to get back home? And then what did the blackout end? You drove on the parade route and then you just said, "F it," you're upset again, and then you blacked out until you tried to get away? That's my question. He's not a good what? A good criminal? Mhm. Yes. He doesn't know. So it's convenient for him to blame someone else. Just like he blamed Marcus, whoever he is, if it's even a Marcus. Maybe it's a friend he had before. I'm not sure. You know, you blame Erica, you blame Marcus for being stranded, even though we know you weren't stranded. It's always going to be someone else to blame. I agree with you. I agree with you. I understand that part of it. I think she's dead wrong for defending him. I do. I do. But it's just that there's nothing, unfortunately, to charge her with. There's nothing. So sorry, uninsured motorists. Wouldn't that be if you got into an accident and let's just say if you didn't have enough insurance to cover another person's damages, your insurance will cover it and vice versa? Am I misunderstanding that? Even still, you can't drive off a lot without having your car insured, right? You have to have, in Ohio where I live, 2550 at least. You have to at least have liability insurance to drive off of the lot. Maybe I'm not understanding it correctly, so y'all let me know. Okay. What's offensive to me is he's convinced himself that he was innocent in there, that he's actually smart. Okay. I don't like that he convinced himself and tried to convince us and insult our intelligence by saying we didn't see what we all saw. So I agree with you there. Okay, so Dawn bought the vehicle from a second chance financier. So as long as she bought a 30-day policy, it makes it harder to underwrite the insure. A 30-day binder will possibly, or I'm sorry, probably sent to the car lot. Ooh, okay. I think that too. I think a lot of things. I think a lot of things. I do. But he wasn't taking her to work. Right. He wasn't taking her to work. Remember, my mom has to catch the bus in a dangerous neighborhood. I don't know, Terry. I don't think she bought the car for him to drive her to work. She's always caught the bus, so I don't think that's the case. And I don't want to say that she purchased a car for him to live in because I don't know. I just know he did live in it. So I'm not sure. I remember that. I remember that. Policy came in 30 days, 6-month annual policy is 35, cannot be canceled once active. Oh, this is a whole case study about this insurance. Hey, Annie. Oh my goodness, at work, but listening. Thank you so much for the support. I appreciate it. Do you really think that she thinks he has mental illness, or like Judge Darrell said, that it's easy for them to think he has it because they don't want to believe what he did? It's a lot it's a lot of stories where a criminal will commit a crime and then it's so convenient for them to all of a sudden have mental illness. but they never had it before. I think I'm on Judge Darrell's side with that one. I think it's easier for them to convince themselves that he truly does have a mental illness. Otherwise, he would not have done what he did. It's easy for them to just say that to everyone else so that we can kind of soften up. Okay, let's see what my girl Shonda's saying. Oh, okay. Thank you for clearing that up. Gotcha. 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 Okay. It absolutely is.
Jennifer and Kathleen were support people. Jennifer's daughter was marching the parade, and then Mitchell was there to hand out candy with his stepmom.
Okay. I'm gonna now play. It's still not being displayed on our tables, Your Honor, but it is displayed on the 2 large monitors in the courtroom. So do I have permission to proceed?
Which exhibit?
This is 32.
Oh, yes. If we get to a new one that hasn't previously been received, then
Yes.
I will
Okay.
pause to get
All
the
right.
tech people in.
All right. And
Go ahead.
Objection
Bailiff.
to relevancy.
Overruled.
the bailiff confirmed it's on in the jury box, Your Honor.
Thank you.
All right, please play. From the 32-second mark, I'm sorry, 35-second mark to 47 seconds.
How long is the exhibit?
Looks like it's 1:23 according to what I can see on my monitor.
Definitely.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection, speculative.
Overruled. He may answer.
Yes, I do.
Could you identify them by using the touch screen?
Objection, leading.
Overruled. He may answer.
I'm going to draw one big circle.
Okay,
It has 2 individuals. It has Jennifer and Kathleen. Kathleen has the red jacket on, and directly to her left would be Jennifer in a black jacket.
okay. A little hard to see right now, but as they,
Very hard to see.
Shut up!
did you see 2 people walking there, sir?
Yes, ma'am.
Okay. Please clear the screen and continue playing and pause. And I'm sorry, because I can't see the counter yet.
It is at 44 seconds.
44 seconds. Thank you. Paused at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection, speculation.
Overruled. He may answer.
Yes, I do.
And who is that?
Leading.
Mitchell,
Objection.
Overruled.
Mitchell Lampine.
Please circle Mitchell. Do you know Mitchell's approximate age?
Objection, speculative.
Overruled.
I believe he's about 10.
All right, we can take down 32. This video goes on to show the red SUV drive through the extreme dance team, correct?
Objection, leading.
It's foundational. Your Honor.
Overruled. It's foundational. It's previously been received. Go ahead.
Yes, it does.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection, leading.
Overruled. The witness may answer.
They were hit by the vehicle and then moved to the left.
Detective Casey, Exhibit 55, can you see at the end of the road there or the top of the screen what unit is involved in Exhibit 55, please?
Yes,
Please tell us.
Objection, leading.
Overruled.
it is the dancing grannies that are approaching from the right.
Okay. And one of the dancers, we have heard testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that correct?
Objection, leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospital being struck by the SUV?
Objection, leading.
Sustained as to the form of the question. Please rephrase.
Sure. Is exhibit, you've seen Exhibit 55 before?
Yes, I have.
Are you able to identify Ms. Hospital, I'm sorry, yes, Lola Hospital in Exhibit 55, sir?
Objection leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor, from from 4 seconds to 8 seconds at 50% speed. And it is zoomed in on the middle of the road where the dancing grannies are located.
All right, go ahead. Thank you.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the dancing grannies and hitting Lola Hospital and then striking 2 other dancing grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Ms. Hospital report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
Sir, do you recognize the item shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection leading.
personally?
Overruled. The witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading. Informative. The first part of the question.
Overruled. The witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark for the record.
Your objection is noted, and the answer will stand. I will instruct the witness to simply describe what he's seen without further characterizing it, as it will be up to the jury to determine the facts in this case. Go ahead.
Thank you. When you saw these items on the hood of the red SUV, did you later come to recognize where they may have come from?
Objection leading.
Overruled. The witness may answer.
Yes, I did.
What did you determine?
I determined that they were the jacket, hood, and hats that Virginia Sorensen was wearing while she was walking in the parade.
Like to display to the witness only, please, Exhibit 177. This has not yet been received, Your Honor.
All right, go ahead, please.
Is 177 on your screen, sir?
Yes, it is.
And what do you see in Exhibit 177?
Objection leading.
Overruled.
I see 2 dancing grannies carrying a Milwaukee dancing granny sign, and the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to the relevancy.
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Said 177.
177, yes.
And again, just so we're clear on the record, please circle Virginia Sorensen in the hat in this picture.
Objection leading.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
Detective Casey, there were many videos that have been shown to this jury, correct?
Objection. Leading.
It's foundational, Your Honor.
Overruled. The witness may answer.
Yes, there has been.
To your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection. Leading.
Overruled.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Yes, there are.
I'd like to display for the witness only.
Is Darrell looking up at Detective Casey, or is he looking at his reports like he did with Detective Carpenter? They haven't shown him in a few minutes, or at least I haven't been looking. I want to know, is he making eye contact with Detective Casey while Detective Casey is waiting for him to object?
Exhibit 150.
Go ahead.
Is
Well, he
150 on your
looking
screen,
down.
Detective?
Not yet. It is now.
All right. Do you see Exhibit 150?
Yes, I do.
Please describe what you see in Exhibit 150.
Objection. Leading.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to admit 150 and permission to publish.
Objection. How does this go to investigation? Exhibits
Overruled.
on investigation.
Exhibit 150 is received. Permission to publish is granted.
The image is a little blurry, correct?
A tad.
Can you please point out the license plates in the photo and read it for the jury?
Is it okay if I circle it?
Yes.
Overruled. You may do so.
That is the license plate number, and I read ADP 9256.
All right. Now I'd like to show to the witness only number 151, please.
Go ahead.
Please describe 151. Oh, please clear the screen, Madam Clerk.
This photo is of the red SUV on the parade route. It's just photo taken just prior to the Barris Logistics float, and the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Oh, God.
Objection to relevancy.
Exhibit 151 is received. Permission to publish granted. The objections noted and overruled.
I recall this station had 140 exhibits. How do we get this many?
So,
Keep going, Attorney Upper.
Detective, please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Objection. Leading.
Overruled.
ADP 9256.
Detective Casey, during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection. I don't consent to being called their name. He's leading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection. Leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Go ahead.
Please identify 175.
This is
Relevancy.
Overruled.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection leading.
Overruled. The witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
a
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is
Overruled or sustain?
Overruled.
You said sustain.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry, I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that for any confusion I may have caused.
This is a screenshot taken from a video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the alleged defendant in here.
Uh-oh.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
Detective Casey, is
Ooh.
person you know as Darrell Brooks in this photograph?
Objection, I'll consent to being called their name.
Brooks.
Leading the witness.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion. How do you know that's Darrell Brooks there? His back is to us.
Objection leading.
Overruled.
I've watched the video in its entirety, and I've seen his face in the video.
Okay, that can go down, please. Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection speculative.
Overruled. You may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each. So I would say probably 300 to 400 videos we've collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, they were not.
Objection leading.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection speculative.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection leading.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection speculative.
Overruled. The witness may answer.
None of the videos that we had looked at showed anyone else in the vehicle.
Do any of the videos at any point show the red SUV coming to a stop, a complete stop along the parade route?
Objection leading is
Oh.
speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection leading.
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection leading.
Overruled. The witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some reports like that.
When the vehicle was found on Maple Street, you weren't there.
Correct.
Lady.
Overruled. His answer may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection speculative. Just stated he wasn't there.
Overruled. The witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection lady.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection lady.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where it interviewed the people that reported the people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection lady.
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
My understanding that that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection. I don't consent to being called that name for the record.
Noted. Overruled.
How did you get it?
Objection lady.
Overruled. The witness may answer.
You just stated how you got it.
Overruled. He may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection lady.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department Secure Storage Facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you find?
Objection lady.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Uh-oh.
Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection. I don't consent to being called that name. Please.
Overruled. Foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection lady.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection. I don't consent to being called that name.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection lady.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verify that is his name that he has always gone by. I have also spoken to his mother, which states that that's the name that he has gone by always.
I'd like to put on the screen for the witness only
I
exhibit
think this
88.
is what pissed him off. You don't want to talk to my kids? Because y'all know he don't have a relationship with his kids at all. So now you going to go find out all of my business that I ain't no good daddy. I ain't no daddy at all. Then you going to talk to my mama? And his bald-headed mama probably did not tell him that she talked to Detective Casey. Y'all in trouble now, okay? I hope they realize that Darrell is over there probably boiling.
8. Do you see Exhibit 88, sir?
Yes, I do.
Objection to this was the
Uh-oh.
Overruled. Go ahead.
grounds for the overrule.
Relevant
In what way is it relevant?
to the counts alleged in this case. Go ahead.
Can you please identify Exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks, the date of birth of 2/21/82.
Uh-oh.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection leading.
Overruled. The witness may answer.
Yes, he was.
And what is the date of this bail form, please? I believe it's near the bottom.
The date on the bottom
Objection
is
leading.
Overruled. The witness may answer.
2/21 of 2021.
Was Mr., we'll strike that, by classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. You've already made a ruling on it.
Overruled. The witness may answer.
All the charges that I see on here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the third bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection leading.
Overruled. The witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
I'd like to display for
We've
the,
already speculated to. How's that coming into evidence?
Overruled. And permission to publish.
I'm sorry, I did not seek to publish this, Your
Oh,
Honor.
all right. Turn that
I
off.
request a legal finding of fact for that.
The objection is noted. It's overruled. Continue. Attorney Opper.
Thank you. I'd like to display for the witness only Exhibit 89.
Go ahead.
Sir, can you please identify 89?
Objection.
Overruled.
Relevancy.
Overruled.
This is
This has been speculated, stipulated to as well. How's it evidence? How's it being admitted?
The objection's noted. It's overruled. The witness may answer.
I request a legal finding of fact for that too, Your Honor.
Noted. Overruled. Go ahead.
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks with the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in Exhibit 88?
Objection leading.
Overruled.
Yes, it is.
Are you able to make any observations about the level of charges related to this case, sir?
Objection leading.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Okay. And on the bottom of the form, can you tell the date that this bail was issued?
Objection leading.
Overruled.
States 11/11 of 2021.
The directing your attention again to that same location in the middle of the page under paragraph B, the third bullet. Could you please read the conditions of release that were set by the court in that case?
Objection leading.
Overruled. The witness may answer.
Defendant shall not commit any crime.
To your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Finally, sir, I'd like to put up one last item for you, or 2 items. I'd like to display for the witness only Exhibit 13.
Objection. What's the relevancy of this? How does it say any foundation to testimony?
I'll give the state some leeway to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell if Exhibit 13 is a video, sir?
Yes, it is.
Okay. Have you seen this video before, sir?
Objection leading.
Overruled.
Still relevancy.
Um,
Where's the relevancy?
the state is asking the foundational questions. The objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection leading.
Overruled. The witness may answer.
Objection speculative.
Overruled. Go ahead.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. It also has the address of Dawn Woods, the mother of Darrell Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the lower
Objection.
right,
I move to strike that. How does he know what?
The objection's noted. Overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
in the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
Objection leading.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
Objection leading.
Overruled.
To me, it means that the video was taken on November 21st, 2021 at 1:26 p.m.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
Objection speculative.
Sustained. If you could lay a little more foundation.
Sure. How did you come into possession of this video, sir?
The defendant's mother provided it to us.
And do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection relevancy.
Overruled. The witness may answer.
Yes, she was.
Do you know if the video was provided to police when asked?
Objection leading.
Overruled.
Yes, it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
Come on, man.
I do not.
Move to admit 13, Your Honor, and permission to publish.
Objection. Where's the relevancy?
Noted. Overruled. Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed. Detective Casey, were you able to see any emblem on the front grille of that vehicle as it drove away?
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection leading.
Overruled.
I did not.
I'm going to put up State's Exhibit 14 now, please.
Now, this is the question that I have. They said that the video timestamp was 1:18 p.m. Milwaukee is only about 20 minutes or so from Waukesha. Let's just say maybe even 30, depending on traffic, right? So let's just say he got there. Let's just round it up. He got there at 2:00. Was he harassing Erica for a whole 2 hours and 30 something minutes? Do y'all think he was harassing her that whole time, or was he really somewhere else and then met up with her? And I'm not saying he was there with Marcus and Stephanie. I'm not saying that at all. I am just trying to get a clear timeline here. You're right. See, because a public defender, like I told y'all in the beginning, they would have tried to suppress as much evidence as possible. And they would have a clear understanding of what evidence was admitted into discovery and how the state could potentially use that. And with that information, they can formulate their own questions, when it's their turn to cross-examine. Yes, she is. She is setting him up. Who said that? Somebody said that earlier. Where that's at? One of y'all said that. She's setting him up. I can't find it right now. Because it wasn't him. The person in the video got long hair and a beard. It ain't him. Do you think he knew that his mom? No. I don't think that his mom, listen, it could be one or two things. I don't think that his mom told him, or she can say that they threatened her, or in his terminology, coerced her into giving them that. She's a big liar too. So it's no telling, what she told him. Because I'm pretty sure after this day, he went back and confronted her about that. Absolutely. Absolutely. And I don't think that he realized just how much research and investigation they would do, you know? I think that he thought it just stopped at, okay, they think they saw me driving through this parade. You know what I mean? I think this really threw him, you know, because you gonna go talk to my kids for what? What do you need to talk to them for? Why are you looking on my social media page? And why are you talking to my mother? You don't need to talk to my mother about anything. Why are you getting information from her about if I was in the backyard, if I actually took a car? So absolutely, I think she lied to him in some type of way. Or he cussed her out and that's why she didn't show up. And doesn't that lead us into yellow shirt day, I believe? You going to bed? Don't leave us. Hi, welcome, Angelica. Thank you. Thank you for being here. We are here late. I think so too, Damien. Good to see you. Hope you had a beautiful day today. Yep, he fell right into it because people like him have a strong desire to prove themselves, right? So, yeah, they always want to catch somebody else in a lie because that's going to take the attention off of him and try to make it look like they invaded his privacy. They infringed on his rights. You know, he's going to even mention that. What are you going to talk to my kids for? Right? I love the way y'all think. Yes, I know. She had to cover her tail. And I don't think I've ever seen you before here. Welcome, Tracy. Thank you for coming. Oh, cool. I really want to try to beast through this. I know we've been on here for over 2 hours, almost three, and a lot of y'all got to go to work, so you might have to catch the replay. But I really want to get through this, as much of it as I can, so that we can go straight into tomorrow's live, which is the 50-minute rant. So, well, thank you for coming. It's so great to have you.
Go ahead. Just to the,
Yeah, just to the witness only, please.
thank you.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Move to admit 14 and permission to publish, Your Honor.
Objection, relevancy.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see Darrell Brooks in this photograph?
Objection, I don't consent to being called that name again for the record.
Noted. Overruled.
Yes, I do.
Can you identify or, describe the clothing items that you see him wearing in this photograph?
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue colored flip-flops on with white socks.
All right, thank you. Any other questions, sir?
Why he look over there like that? Oh Lord, this man works me. Had a great day with my beautiful baby daughter. Oh, it was. I had to work, but you know what? I'm thankful that I have a job, so I'm not gonna complain at all. But I had a great day as well. She probably was. I know someone else mentioned that, like, she's probably relieved that he is in prison. Because the thing is that even though I'm sure the goons in jail are gonna make his life a living hell, she doesn't have to really worry about him. He's off of the street. He's gonna eat every day. He gets to see a doctor. That's about it. He's off the street. I mean, he can commit crimes in jail, but ultimately he's going to be housed somewhere. So you're right. She doesn't have to worry about housing her fugitive son or hearing about the next crime he committed or anything of that nature, or even, I guess, protecting herself. A lot of people believe that she was afraid of him. So, I don't know. Maybe she can sleep better at night knowing that her son won't put the paws on her anymore. That's a miserable life, though, you know, on both ends. On both ends. Thank you, friend. So you think he was driving around for 2 whole hours harassing her? Jesus. Gosh. I'm so glad she doesn't have to be bothered with that anymore. I'm telling you.
We cross.
In the two exhibits we just watched, 13 and 14, do you see anyone driving the vehicle?
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
I would assume, based on my training experience, that when the vehicle pulled away, that there was someone inside the vehicle. Because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question.
Well, what kind of question is that? Is somebody in a vehicle? And that was your question. He's so pissed off, y'all. There is such a difference between when he cross-examined him the first time until now. Like, I'm so tired of this man.
Do you see anyone in the vehicle?
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections, not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to exhibit 175 and pull that up for the witness.
Okay.
You just testified that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only exhibit photo from the video?
Can you clarify the only one that is shown today, or the only one that has ever been taken?
The only one that's
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
Did he not hear him say that he watched the video in its entirety and he was able to get a snapshot? They didn't need a snapshot of you. They needed a snapshot of the car, sir. He's looking for another mic drop moment. This is so delicious, y'all. This is so delicious. Oh, God.
I'm asking the question.
From just looking at this, no. But I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony right now at this moment. Strictly that.
Could you ask your question, please?
I'm going to object, asked and answered.
Sustained as to the form of the question as well.
Would it be fair to say that from this exhibit 170?
Hold on. Do you have a source for that? I know somebody else had mentioned that. I didn't see any jail records that said anything like that unless there's a CEO leaking information. Right. Exactly. Exactly. That's why I just oh, I can't wait. I'm rubbing my hands like Birdman. Ripping it off the hinges. Okay. Yes.
25 that they're looking at right now that you cannot tell who the circle individual is. Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Thank you, Madam Clerk.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video. Some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? I mean, the usage of that vehicle?
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained as to the form of the question, if you could limit or perhaps direct him to a specific time frame regarding the use of the vehicle.
At the time of the incident?
Yes.
And can you clear that? And what information was that?
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
I'm gonna go another route on this.
You done with the exhibit, sir?
No, I'm not.
So you're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
You just testified to seeing the entire video that this steel frame exhibit came from, correct?
I testified that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety what we recovered from your social media account. I'm not sure if there is a longer version someplace, but
Did you see the video in its entirety? The video that this exhibit came from?
yes,
And are these the only two individuals that you observed in that video?
they are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
No, I have not.
Can you clear that circle? Would it be fair to say that from looking strictly at the exhibit that we're viewing right now, both individuals have the same hairstyle?
It would be fair to say.
Can we clear the X's and clear the exhibit?
Go ahead. Thank you.
We go back to exhibit 13. Well, just play it out. I'll tell you when to pause if that's okay. I don't think I'm gonna need the. Well, I don't know. I might. Pause. Right there, the individual that you observe right here. Do you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
No, I don't see a video or a hoodie anywhere in the video.
Can you take the X down? From this angle, it'd be fair to say that you can see the very front end of a vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside the vehicle.
This has been asked and answered, Your Honor.
I'll allow it. The witness may answer.
This is a whole different.
I'm allowing it. Go ahead.
That is correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it'd be fair to say that you're not sure.
It's Fair to say that I am not sure.
Can we pull this down? Whoa, wait. I'm sorry. Can you pull that back up for 1 second?
Same exhibit.
Same
Go
exhibit, 13.
All right. The state would put that back
Right.
on display,
It
and there you go.
Do
Do you want any more of it played or just the still?
we waiting for the jury, or do they?
It's up.
No, we don't need it played.
Do you need it to go to a certain point?
Yes,
All right. Do you know what point?
I'm about to it right now. Looking at this house right here, do you see an address posted anywhere on this house?
In the photo that you circled, no.
So it'd be fair to say that you don't know the address of this house.
That is incorrect.
You just said that you don't see an address posted anywhere in this house. So from the vehicle, strike that, not the vehicle. I'm still looking in the corner right here. From the video that we're viewing right now, do you see an address posted anywhere on this house?
I do not see an address posted in this photo.
So judging by this, well, actually it's a video, but judging by this video, how can you know the address of this house?
Because I've been at this house before to talk with your mother. I've seen the address on the front of the house.
Judging by this video.
Hold on. You have to let him finish because that was not the question you asked. You asked him how he knew. He can answer. Go ahead, Detective Casey.
I have been at this address before. I have spoken to your mother. I have been in the backyard of the residence. I've seen the address on the front of the house. I know this to be your mother's house. I recognize from this photo to be your mother's address.
If you're referring to the video, the ring cam footage, Detective Casey got it the night. He says the night of the 21st, but his mom was at work. So maybe this is just the recording. Well, we know this is the recording of him prior to going to Waukesha. So maybe the next day he got it because his mom, was at work that night. So, okay, Monica, thank you. Thank you for staying. Thank you all for being here. It is 11:30. Thank you, y'all.
4014 North 19th Street.
You recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
I believe that I saw the video first, and then I was at the address.
So at the time that you saw this video, you didn't know whose house that was?
That would be an incorrect statement.
You just said that you saw the video first before going to the house. Did you, or did you not say that? Would that be fair to say?
I guess I'm a little confused in your question. We received the video. We know from getting it from my mother that she said that that is where she lives. So I knew that this was where she lives when I watched the video. That was clarified for you.
I follow you, but that clarification wasn't stated before. So that's fair from the clarification of how you just clarified it. Can you clear the second, please?
This exhibit?
Yeah.
All right, we'll take it down. Thank you.
You made reference to a key being found.
Sue Opera is over there patiently waiting for her mic drop moment. Zach has been typing the whole time on this laptop. I don't know what he's looking for. And Leslie is sick. Gosh, please hurry up. I can't wait to this part. I love this part.
Did you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No, I was not.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
What are you speaking of?
The key being found.
That's correct. I was told by two officers who I've worked with for a long time, and I trust what they tell me to be accurate.
You made reference to there being a couple, what's the word you used, a couple ways to identify individuals. And you stated that you had spoken with
the mothers of the alleged defendant's children. That'd be fair to say?
I believe I said I spoke with the mother of 3 of your children.
At that time, was the alleged defendant already in custody?
Yes, he was.
Wouldn't it have been easier to just use the fingerprints that were already obtained?
Like I said before, the fingerprints was one way. We also verified it talking to his family members that his identity.
Any reason why, or let me back up. Is it fair to say that there was more confirmation needed to identify the alleged defendant at that point, seeing as how the fingerprints were already obtained?
We were just being thorough. We were certain that it was Darrell Brooks that we had in custody based on his fingerprints and other information that we had. It was just a matter of being thorough and verifying the person that we had and the name that he goes by.
It'd be fair to say fingerprints are pretty accurate though, correct? That'd be fair to say?
I think that would be fair to say.
So it would also be fair to say that there wouldn't be any reason why the alleged defendant that was in custody would be someone else. Wouldn't that be fair to say?
Objection, that's compound and difficult to follow.
It's not compound. It's
Sustained
not
is to the
difficult
form of
follow.
the question, sir. Please
That was
rephrase.
very clear.
Oh,
Sustained is to the form of the question.
And where did the interviewing of the mothers of these children take place, if you recall?
I spoke to Jessica Macklin in Iowa at her residence.
oh, he done gave out the
Yes, ma'am.
whole government, y'all. What was her name again? Let me run the record back. Oh, wait.
Sir,
It's ridiculous. So you said you went to Iowa to try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
sustained as for all basis. Next question.
Was that an attempt to prepare for what might have been said?
Oh, did I go back too far?
I'll allow that.
Okay.
Go ahead.
Yes.
Why would there be preparation
Oh,
involved
man,
in?
I think I done messed up. I'm trying to hear when he gave the girl government out. Wait. Hold on.
Sir,
It's ridiculous. So you said you went to Iowa to.
Maybe I just need to leave well enough alone. I just got to hear it again.
You spoke to in Iowa.
Correct.
Why would you go all the way to Iowa?
Because initially you listed her as a witness.
overruled. He was answering the question. His answer may stand. Your request to strike is denied, and the witness may continue answering.
I spoke to Angel Fitzpatrick in Menominee Falls at her residence, and I spoke to Erica Patterson a number of times at various locations about you.
Mm-hmm.
You said one of the mothers of these children you spoke to in Iowa.
Correct.
Why would you go all the way to Iowa?
Because initially you listed her as a witness on your witness list for court. So we went there and we wanted to verify what information she might have that she would testify to.
And that's what I'm wondering. You don't take care of any of your children, so I'm assuming this is the mother of his daddy's girl. You don't take care of this little girl. So why would you put her down as a witness? Was this supposed to be a character witness for you? And what's she gonna say? What is she gonna say about you? This is funny.
Just for the record,
What?
I don't recall listing anyone as a witness. Just for the record.
For the record, Mr. Brooks, you can't.
Do y'all think that his previous attorneys reached out to her to be a potential character witness for him, or he did that? I don't have the witness list. And I know during jury selection he was very he didn't want to provide the state with his witness list. Originally Don was on it. His bald mama. I'm wondering. Tell me what y'all think.
Can't testify at this moment. You'll have an opportunity should you choose.
I just wanted that clear for the record. Since
No,
what was
Can't be.
said,
It's struck from the record at this
I-
point because you're attempting to testify.
I'm
The
not
jury
attempting
will
to
disregard
testify. I
that.
just wanted the record to show.
No.
The
And I
jury
had no
will
knowledge of doing that. And if
the jury will disregard those statements made by the defendant
If
as
something's-
he is not testifying, and it would be improper at this time for the court to receive them.
I don't think a
Go-
record should be
next
made of
question, sir.
something that I didn't do.
Next question, sir.
It's ridiculous. So you said you went to Iowa to try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
Sustained as for all basis. Next question.
Was that an attempt to prepare for what might have been said?
I'll allow that.
Okay.
Go ahead.
Yes.
But I'm just wondering, what were they expecting from her, especially given the fact that if he has no relationship with his daughter, that just doesn't make sense to me. They can't speak positively on his behalf. I got to get my hands on that witness list. It is. It is. You see the facial expressions he's making? Like, aha! Caught your ass.
Why would there be preparation involved in someone who might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Overruled. I'll allow it.
We went there to speak with her, so if she came and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
So you made reference to not being any surprises. Would it be fair to say that there was a little worry there?
Not a little
Objection,
worry.
argumentative.
Grounds.
Sustained as to the form.
Look how they laughing at him.
What surprises were you referring to? What do you mean by surprises? No surprises.
Your Honor, I object to this entire line of questioning. This witness is not expected to testify. It's wholly irrelevant.
He opened the door by putting the name on the record and saying where you went.
I will allow one more question on this. Go ahead. You may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may.
Now, I will say that they should not have allowed Detective Casey to give her last name, because that sets her up for being harassed. She has nothing to do with this, especially if she's not being called as a witness. Unless they put her in some type of witness protection program, I don't think that should have been allowed. Just for her safety and for the safety of her child. So, I don't know.
Come up later that would be helpful in the trial.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained as. Next question, please.
Reason for the sustain, Your Honor?
Not relevant.
Well, the question was asked, does he recall?
Sustained. Next question, please.
Grounds for the sustain again?
Relevant.
How's it not relevant?
Uh-oh.
Keep going, sir.
How
Did
you
you
gonna tell him his daddy's girl ain't relevant, Judge Zorro? He steady banging that little pen. Lord have mercy.
interview the child?
Same objection.
Grounds.
Sustained.
Oh,
Grounds for the sustain?
Relevant.
relevant.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained. Move on.
I would
Mr. Brooks.
object that trying to interview a 7-year-old child is
Sir, move on, please. 90611. It's also not relevant. Assumes
Very
that's not
relevant.
an evidence.
it was a tricky move. You made reference to
You're a tricky move.
in regards to Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, I do not.
So how did Milwaukee County, which is a different county, come into your investigation in Waukesha County?
You may answer. With the understanding there are some limited pretrial rulings that
We
still are
know
in play.
Detective Casey, he is a whole clown. We know that you had to do some investigating to learn of his criminal history as part of the investigation and a part of the evidence for this trial. We all know why you did that. This clown doesn't. So, yes, we appreciate your laughter.
During the normal,
I'm sorry for interrupting. I started off by saying in regards to exhibit 88 and 89.
Okay.
That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial ruling.
Okay.
during the normal course of an investigation, we do background on a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
In reference to having charges in one county and potentially being charged in another county, in reference to that, wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
That is an inaccurate statement.
Very.
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
No, sir. You are in violation of probation in several states, sir. You've been on probation for a number of years and continue to commit crimes in Nevada, Milwaukee, and Waukesha. So, yes, they can charge you with a crime and they can charge you with felony bail jumping. You violated the conditions of your bail conditions. And we all know what double jeopardy is, so there's no need for me to elaborate on that. This is just theatrical at this point.
I've heard the term before.
And what is your understanding of what that term means?
Objection, irrelevant, beyond the scope of the witness's knowledge, legal conclusion.
Sustained for all those reasons.
Please.
So when did you become the lead investigator in this matter?
That was about 8:30 p.m. on November 21st, 2021.
So same night?
Correct.
Whom were you made lead investigator by?
The command staff for Lieutenant Jerry Habanik.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person and had the most experience to take care of it. That's what I've been told.
Any other reasons besides that?
Also because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in. So I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And that would be the information that you said you had more knowledge of than anyone else at that time. Would that be in reference to having an interaction with the vehicle at some point?
I would say as a totality of the situation, I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
You referenced you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
I meant that I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this instance?
Now, did he say that before? I know I'm a little tipsy right now, but did he say that before? I don't recall hearing that, but okay.
incident?
We'll let him have it.
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean,
You
a
mean
horn.
the vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
What would be the only time a vehicle would beep their horn?
Objection,
Grounds.
speculation.
Sustained. Calls for
Reason.
speculation.
Do you know why the vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
I've been driving a long time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
I assume that he was.
So it'd be fair to say you don't know for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name.
Did you
at that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold on.
saw him?
Compound question. Ask one.
I was just giving clarification of no,
You
what I
need
meant
to,
by
it's
no.
a compound question. Please rephrase.
Before you observed this vehicle, as you say, this driver that, as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds.
Sustained is to the form of the question.
How would you know how someone's feeling if you don't know who they are?
Your Honor, he opened the door to this,
Uh-oh.
asked and answered. The witness has given his opinion. It's clear.
Grounds.
I object. Improper question.
Grounds.
I will allow the witness to answer.
See, now, what's this lady's name? Judge Darrell. I'm getting a little exhausted with you, ma'am. First of all, these are questions that he already asked when he cross-examined him the first time. You're letting this go on too long. It doesn't matter if he knew him before or not. We're not going anywhere. Let's do something about this, Judge Darrell, now. Come on.
Why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
So would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Objection,
Grounds.
irrelevant, speculation.
Grounds.
I'll allow it based upon his training and experience. He may answer.
It's a possibility.
And did you hear this beeping before the vehicle approached you?
Yes, I did.
It made reference to, and I'm referring to the ring video obtained in exhibits 88, or I'm sorry, the ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself have been present for all testimony. Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to, let me clarify. Maybe I wasn't clear enough. Pertaining to all testimony since trial began. You've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of, and I'm referring to again, so we're clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street, that you testified to obtaining the ring footage the same night. Were you aware that? Well, let me back up just a little bit. How were you able to obtain that ring footage?
There was officers that went to Freighter Hospital. One
Gotcha.
was
Okay, so that answers our question because remember earlier I said I didn't know how they would have gotten. Let me let him finish first. Hold on.
Mr. Brooks's mother was working. They spoke to her, and she's the one that alerted to them that she had Ring video at the house
Ooh.
and offered to remotely download that video for them.
Okay, so that's how TY, if you're still here, that's how they got it. So remember, I was inquiring about how they would have gotten that from her, given the fact that she was at work and they got it that night. So they went up in her job. Could you imagine you working, right? You working, she working at a hospital. First of all, you getting ready for work. You look outside, the car ain't there. She probably thought nothing of it because he does this all the time, right? And so at some point, you log on to social media and you see your maniac son driving through this parade, just losing his shit driving through this parade, right? And so then you decide, oh my God, what am I gonna do? I gotta let me call the police because I just need them to know I had absolutely nothing to do with this. So she calls the police. She tells them, I think that red SUV is my son. He stole my car. I didn't know he had it. This is his name. This is his date of birth. Do what you got to do, right? So then a little bit later, your son calls you and says, Ma, I need you to get me an Uber. She obliges and gets him an Uber, right? So then you get to work thinking, okay, well, whatever. I don't know where he at. It ain't my problem no more. So now you done clocked in to work. You thinking, okay, I'm just about to work my shift. And the police shows up. The police shows up and says, look, you said this is your son. We need proof. And she starts shaking in her boots and says, okay, hold on. Let me show you this ring footage. I'm a download it and then I'm a airdrop it to you. And what makes it even worse is the fact that they got this ring footage the night of this massacre, right? So the whole time she knows she gave it to them. She probably didn't tell Darrell because he didn't know she had it. He has not checked these bankers boxes for his discovery, which it has to be in there, right? So this whole time he didn't know his own bald headed mama done talked to the police 2 times now, y'all, 911 and to these investigators, these detectives, and they got the whole ring cam footage of you getting into this car. Oh my goodness. Thank you. Thank you for being here on the late night. Good. I'm glad you heard it. You still here. Girl. I desperately want to know. I want to know what the phone call was like, okay, after he learned this information. I got to know. He did because doesn't this, if I'm not mistaken, doesn't this lead into the 50-minute rant or something like that? It leads into something because I'm gonna cut it off when it gets there because that's something else. Um, that's something else that I want to discuss because that's what I choose to call her. That's what I choose to call her. Mhm. My opinion, but thanks for coming. Um, so yes, I wanna know what she said to him after he called her, especially knowing that she gave them this information that night. Hmm.
And were you there yourself?
I was not there myself.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't
The
recall
very first time.
I don't recall the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds.
Sustained. Hearsay.
The August 8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation. The investigation continues every day. It's not, and it will not.
Hold on, let me catch up. Oh, okay. It wasn't any offense to anybody, that may be suffering from any type of alopecia or any type of medical illness that causes them to lose their hair, anything like that. And it's no, I'm not trying to be mean to you, but that's what we call Don over here because we have zero respect for her and her son. So I apologize and I'm not trying to be rude. What? What does that mean?
Not end until this trial is over.
So what follow-up was needed at the time of the August 8th interview? I'm guessing that's what you would call it. I don't know. I'm not sure.
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Miss Woods multiple times?
Because every time we spoke to her, we got different information. And at that time, we were following up with your niece and nephew of what their testimony would be in this case.
They don't talk to your kids. Their mamas, your mama, your niece, your nephew, and now they saying that the story keep changing. You're toast, my guy.
What testimony are you referring to? Because I don't recall any nieces or nephews testifying.
I don't think I'm allowed to say it.
I think this line of questioning is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break, I can address it further if need be. Please move on to a new topic, sir.
You made reference to people who were injured at the parade inadvertently. You recall that?
Yes, I do.
To your knowledge, were any of those charged?
My testimony before is that those people's cases were not charged.
And were they seen as victims?
Going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not. I asked to his knowledge.
I'll sustain the objection as to the form of the question, if you could please rephrase.
I'm gonna go a different route. Do you recall serving a warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It's for Mr. Brooks's jail cell.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case.
Now he going back to when they flipped his cell looking for the manila envelope folder that had information about using an insanity plea. Why are we talking about this? Now, I know his lawyers tried to get the case dismissed based on that they either requested that they dismiss the trial or that the judge remove the prosecutors and replace them with new attorneys. And she dismissed both. She said no, forget about it. Um, and so why are we talking about this now? What does that have to do with anything? You're not using that defense anymore, so why are we talking about it?
I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
What was the warrant pursuant to?
I sustain the objection. Next topic, please.
He did answer.
I sustain the state's objection. I'm directing him not to answer. We'll take it up separately. I'll have you continue with your cross-examine. I'll take it up later.
You made reference to this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
Oh, here we go.
No, I do not.
Do you yourself know if anyone filed a claim in this matter?
Can you be more specific?
Do you yourself know if anyone filed a claim in this matter?
Just in general,
Whatever your interpretation of that would be.
I
Oh,
would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. I imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it'd be fair to say you don't know for sure.
That was my testimony.
Is that the answer?
yes.
As lead investigator for this matter, are you, to your knowledge, aware of any GoFundMe type of things? in
Objection
relation to-
relevant? I'm sorry.
Do you mean as it relates to?
As it relates to the incident.
Overruled, the witness may answer.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Is it fair to say that there's a lot of communities like that across Wisconsin?
Yes, I think there are.
And it would be fair to say that you've worked extremely close with the district attorney's office.
That's what we're trying to figure out. Okay. When somebody gonna step forward and say something? Why you think they're not gonna say anything? Why you think nobody said anything yet? That's a good question.
During the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it.
Uh-oh.
Extremely.
I'll answer yes if that helps.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in the investigation that sits with the prosecution?
Talking about this case or any case?
This particular case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in
Yeah.
reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over here?
Objection to the relevance, Your Honor.
Grounds.
Sustained.
I just want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. Is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is. That should be known. Nobody
It's
sitting at
not
that
relevant to
table. I
the
don't even
issues
have a
that the
back
jury needs to determine. Next question, sir.
table. Asking or telling?
Nobody tell him what to do.
I'm assuming that's asking. You know what the other one would entail.
I would not let him talk to me like that. I would have ended his cross-examination right there. She absolutely can tell you what to do. I am sick of him. So disrespectful. Like, I don't know how she was just able to take that disrespect. I can't.
Um,
Do you have a question, sir?
yeah, I do. I would like to get to it. Thank you.
Oh,
Please do so. Thank you.
I will.
and gotta have the last word.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection,
Grounds.
legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You are
move to
aware of
strike.
that, right?
Go ahead, Attorney Upper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a legal conclusion in any
The
way.
court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the stated, also as a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I take exception to that ruling and would like a legal finding of fact.
Your objection is noted. It's overruled.
And that's a judicial determination.
Yes, he asked all of these questions already. Like, honestly, a proper attorney, a skilled attorney, okay, would not have even questioned him the second go round. You know, because there's nothing else that you need to ask. But he just cannot help himself. He asked everything except for the knowledge of the lack of knowledge he had regarding Detective Casey speaking with his mom and his children. Other than that, I mean, he just has to have something to say because he thinks they're trying to one up him. Yes. Oh, Debbie, you still here. Man, I'm telling you, I would have lost my law license. I mean, you know what? Honestly, to be completely honest with you, I think that they did try to object, but Judge Darrell gave him so much leeway sometimes to where they just let it go. You know what I mean? It was like, what's the use? We keep objecting. And I think when they did object, they made valid, points as to why he shouldn't be able to ask certain questions. And she would constantly, still allow it. So I think they just let it go. Because it's just like, what's the use? It's just a back and forth, you know? I think that. You see how frustrated Judge, what's her name? Sue Opera is, but I guess you just have to choose your battles. Oh, because he can't, that's just the type of person that he is. It's easier for him if it's already written down or if it's told to him, he can regurgitate it, but I don't think he can come up with anything that makes sense off the top of his head. So there's a script that he's reading off of, especially when he gets to that part about, anybody making a claim, uh, who the prosecution is, and all of that. I think those are just written down. That's what he was able to write down on his own, but he still has to read it. And then the other questions, the ones that kind of make sense, we all know that's just what his previous attorneys had already written down. So that too.
I think you be seated. Go ahead, Mr. Brooks. Please continue with your question.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 90611, I'm not going to allow the witness to answer. It's vague.
There was no objection.
Under
Don't have to be
90611,
one.
I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this
They're
witness.
going to keep coming up.
And I determined at that time that they weren't relevant. So next topic,
They're going to
please.
keep coming up.
Under 90611, sir, please move on to a new topic.
They're going to keep coming up.
For the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will bring it to an end.
You don't got to keep doing that, Your Honor. You don't got to keep doing that.
It's my responsibility, sir, over this trial.
I'm informed.
Thank you.
And I
Next
respect
topic.
that. But it's relevant for the jury to know the truth. They deserve to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
not truthful.
All right, under 90611, I am now stopping the cross-examination. Any redirect by the state?
Objection to that. And I would like
Noted.
legal finding of fact.
Attorney Opera, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take it under
I'm
advisement.
objecting still because
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
Go ahead, Attorney Opera.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir. So let me see it, and I'll take your objection under. I'll take the objection under advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So how could it just?
You did not look at any other exhibits you have, Sue Opera. Come on, girl, and do your thing. Bring it on home for us.
Exhibit.
Go ahead, Attorney
I have
Opera.
all the exhibits.
Go ahead, Attorney Opera. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just create exhibits now. I have all the exhibits. And this was never in it. Oh man.
All right, you can.
We know that you didn't look at any of the exhibits, sir, because had you looked in your discovery, you would have known that your mama talked to Detective Casey and another detective on the night that you plowed her car through that parade. So just stop. Just stop.
Stop. Sir, do you recognize what's contained in State's Exhibit 178?
Objection.
Overruled.
Relevancy.
Overruled. Go ahead
Leading.
and answer.
Yes, I do.
What is it?
Objection leading.
Overruled. The witness may answer.
I'm still gonna object. Houses.
Mr. Brooks, I ask that you
I
honor
have all
the ruling that
I
I've
have
been
all the
made.
exhibits though, Your Honor. I have them
Mr.
all.
Brooks,
They were provided to me, and this was never in the exhibit. So how could it just be made an exhibit?
I'll take
just
this
out of
up
the blue?
outside the presence of the jury, but I'm going to allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence, and the statement
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objections
today.
noted, it's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the
mind-boggling.
Ford Escape. This is the video in which that still photo was taken from.
Objection. How does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
Mhm.
I'll
And
find that
still
it's
don't know how
relevant.
it's
I'll
obtained.
receive Exhibit 168. Permission to publish is granted. For the record.
It's
Could you please-
178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that, and I would like to make an offer of proof of my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without
Your
audio.
Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to
But
address.
how can you play something that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
actually, Your Honor, I changed my mind. I would like to play the audio, please.
Oh,
This is mind-boggling.
look at Leslie.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played?
Hush, math boy fly.
You just
Listen,
set the
listen.
foundation.
That's relevant. You questioned the officer about it. You
I
questioned this
question him
detective
about
about his knowledge.
the still frame from the video. The video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
Oh, I gotta get my hands on Are his social media accounts still up? She is the Patty that I aspire to be. Okay. Oh, that dirty wife beater and them dingy dreads. Lord help us all. Uh-oh, you standing in front of the car?
So play the sound. I want to hear it now.
Get up and rap for us.
I'll address that later.
Be addressed by it. It was created out of the blue.
Oh, God. He said y'all hating on him. He ain't got time to be sitting up in court. He's trying to be a rap math boy alive. Okay. Oh, gosh. Exactly. He should have spent his life trying to become something. Then you would understand what's taking place here. Okay.
Why the fuck you lying? Why you always lying? Oh my god. Stop fucking lying.
I don't know. I think I have no idea. I can't even begin to try to lie. Ray. Oh my goodness. They were. I think they were Instalocks. So that's where they take like
Go ahead, attorney,
let me
after the
pause
video
so
is
I can
finished
talk
playing.
about it.
Thank you.
Look how Detective Casey looking. That's when they take locks that are made from synthetic hair or even human hair, and they are already formed and they attach them to the little bit of hair that you have. So you don't have to go through the struggle of trying to grow your own locks. I believe that's what she said, but it still didn't make sense because the front was short and then the back, like he had a shag or something. Okay, let me see. Right, it's the kid. Okay. Oh my goodness. No, I don't want to watch anybody else do it. I want to get it on my own. Is his social media account still up? Oh my goodness gracious. Right. Oh, right. He had like all these bangs in the front and even like the sides was coming out or whatever. And then it was just like this long, like none of them were uniform as far as the length. It's just a mess, man. Oh my goodness. It wasn't the shade. Yeah, that was Marcus. Marcus didn't drive his tan Kia that day. They took Darrell's mama's car. Oh my God. Oh God. I can't stand him. I can't stand him. What was his name on social media? Was it Math Boy Fly? I'm gonna look on what you call it. My chest is on fire. She did. She did. Yeah, she did. Oh my God. Help me, Lord, please. So was they clipping locks? Oh God. Oh God. Help me. Oh God. Okay. Thank you. Thank you. I just don't want to steal everybody's videos. Like everybody deserves their own credit for doing their own work. So I'm not trying to be mean or anything, but oh God. Exactly. Exactly. Sue Opera was ready for him, okay? I appreciate her. Yes, a whole mullet out here. It was a hot mess. Lord, he couldn't have thought that was becoming. Please. Oh, goodness. Y'all, my throat and my chest. Oh, God.
You, sir, did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, I
A
did.
lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Copper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As
Okay,
to
wait. Let me catch up with these comments. Y'all, I'm trying to catch my breath. Whoo! I think she was really sick this day, so she couldn't really snitch as much as she would have liked. But she probably right. She's still taking notes. She gonna come back with it, okay? Okay. Please, y'all, please give me a minute to breathe. Oh God. Oh man. Oh, now that I think about it, he was acting out to be moved because the block was getting hot. It sure was. This last bit of evidence that they had against him, and the fact that he learned that his mama snitched on him twice, and then y'all done talk to my kids that I don't take care of. He is through at this point. He's through. Oh God. Okay, here we go, y'all. Let's try to finish this up. Woo!
This particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection, I don't consent to being called that name.
Noted. Do you have any questions for the witness?
This, when did this video, when was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That was a question.
Sustained. As to the form of the question.
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did you
the
see
question
this
to be
exhibit?
asked. With that understanding, you may
It
answer.
is.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
Paranoia kicking in.
It would be the same thing. I take that as disrespect because they were allowed to say something, and I said under my breath that was disrespect.
I would direct both parties to avoid commentary.
Okay, well, can you do that, please, and admonish them? Because I'm always the one getting admonished. I take that as disrespect too.
Sir, I'm good. Can I do my job?
Ooh, he's 38 hot.
Directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
all these
the
cameras
witness.
in here. Don't nobody
However,
see nothing.
I'm advising both parties to show
Man,
decorum
this is not fair.
and restraint.
It ain't fair, y'all.
To be respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey. You can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled. The witness may answer.
He got a lot of damn nerve. All the objections that he does. Really? Really? You should have asked the judge, can you take a little break to calm down? Because you so mad right now. Where am I at on these comments? I can't even take this no more. Oh, Jesus. Oh, thank you. My chest, y'all, is burning. Oh my God. Is it still in the playhouse? Oh. Oh, Jesus. I got to calm down. Oh God, I got to calm down.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's
I don't know. He ain't no attorney.
Sustained.
It was not brought up in
question
the
assumes facts, not in evidence.
If you have seen it numerous times before today, why did you need to see it again and make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I'll see what they
Hold on. Objection.
Uh-oh.
Compound, asked and answered. Misstatement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts, not in evidence.
Sustained. As to the form of the question.
This is mine, by the way. This is mine, by the way. Can you clarify again why you viewed the video this morning?
Objection, asked and answered.
Sustained.
So you're gonna sustain everything?
Yep.
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions.
Okay.
Thank you.
This is mine, Bobby.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. Don't tell them all the
Now,
things.
how are they hiding anything from the jury? They've been sitting there the whole time. Explain that to us, Darrell.
Mr. Brooks, I'm going to take up all of your objections outside the presence of the jury. I ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked.
Okay.
I see what you people are trying to do. It's not right.
Okay.
It's not fair and it's not right.
Right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and
Oh my God.
whether it's been turned over previously.
It was previously included in the initial discovery
Oh.
that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I
Oh.
don't consent to being called that name. This is not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr.
By
Brooks, I need to
something
make
that I
a
saw.
record. So just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would-
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
Not at this time,
I
sir.
have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr.
That's why I
Brooks, I
raised the
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons. The first of which, it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, that evidence have. But you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists. And that is my finding as it relates to
What do you mean
that.
by it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? how does it be made an exhibit out of the blue? That was the issue. The issue
State can make
didn't
an
have
offer of
anything to
proof
do
on
with.
that because obviously they marked it as an exhibit.
But
They
with
had
all
it.
respect,
So go
Your
ahead,
Honor, you're
Attorney Opera.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was, how does this at the last minute out of the blue become an exhibit? That was the
Go
issue.
ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection,
aware.
he said social
There's
media.
nothing
He
that.
didn't say
Hold
what it
on,
was.
sir.
Shut up.
Stop interrupting. We have to make a record of it. You've
Then make the record clear.
interrupted multiple times. I've been abundantly
Make
patient
the record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at
Are
me.
you?
Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet, or are you telling me to be quiet?
Go ahead, Attorney Opera.
Thank you, Your
I'm
Honor.
gonna take that
And
as
just
asked.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video, which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up. And whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, Everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction? I believe it was with your mom and possible testimony of your niece and nephew.
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
Y'all notice how, like, when Sue Opper puts him in his place, he doesn't have anything to say. Now, you telling me that Sue Opper can put him in his place, but Judge Darrell can't? And many of y'all are saying she can't because of an appeal? And Judge Darrell sat there and let her say everything that she needed to say because she knew she wasn't saying anything that was incorrect. She let her use the tone that she needed to use. She's frustrated. Darrell didn't say anything. And that's the same approach that Judge Darrell could have taken with him. She could have got firm with him. I've seen judges do it before, and it didn't cause a mistrial, and it didn't cause delays or anything else, or deny or delay their ability to appeal. So that's something to think about, y'all.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stated it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight.
Okay.
Now don't nobody know what I'm talking about.
I don't know specifically what you're talking about.
There's a reference made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations. I didn't say you.
I didn't say you, Your Honor.
No. What I've observed is
listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and he and key. That they've been doing that the whole time. I didn't say anything. I didn't say anything about it.
I have not noticed that. What I noticed are three attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well, we have cameras. That's what the cameras are for.
Let's refocus our attention on what we're here for, and that's
this trial.
I take that. Do you have anything you want to put on the record?
I'm putting it on the record if I get a chance.
No, you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not that she just said she just made it an exhibit. It was not an exhibit before she made it one.
So do you have some legal basis, sir, for your position? Because I'm
What
not.
do I need legal basis for when she just admitted on the record that she just made this exhibit up?
No,
right
she
now.
didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't implying that by saying that she could pull anything out of her suitcase.
So that's a figure of speech.
Okay, so what is it implying to? What would that be implying to?
As attorney,
how would anyone in my position?
Because you're not providing me with any legal basis.
I didn't even finish. You told me that I can make the record. I'm attempting to make the record.
Sir, as it relates to the video and my decision to admit it.
I just said that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either,
because you're not providing me.
But how do you know I wouldn't get to that if I didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you opened the door to the playing of that video.
We're not talking about
opening those doors. And the video was previously provided to you during discovery.
We're not talking about opening those doors. We're talking about being fair.
All right, let's take a little break. We need a little palate cleanser, if you will. Y'all, I got a whole headache from laughing at y'all and with y'all. Okay. Yes, they're all teaming up on Darrell and picking on him. Not only that, Monica, the fact that he thinks that they have worked their whole lives to build a career, okay, out of keeping the general public safe. They wait until they meet Darrell Brooks to throw it all away. And he got the nerve to say the audacity of the prosecution to make such statements. That's very true, Annie. Kelly, I didn't know you still here. Oh, goodness gracious. God. Oh, man. Okay.
Absolutely no prejudice to you in terms of surprise.
With all due respect, if I had done that,
I am going to move on.
If I had done that, it would have been a big thing.
I'm advising you.
Are you asking me?
I'm advising you, sir.
Oh, okay.
I'm advising you to sit down and be quiet. And if you interrupt me again, you are on notice that you will forfeit your right to be present in this trial. So you're holding me contempt. Mr. Brooks.
For the entire trial? Did you say the entire trial?
I never said any such thing.
You said for the trial.
Please.
So what do you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to come at me.
I don't consent to being called
You continue to fight with me.
I'm not fighting with you.
Disrespectful.
I'm not fighting with you. I'm not.
I'm going to give you one last opportunity to sit down and be quiet so I can make a finding as it relates to other things.
Are you asking me
I don't need to ask. I'm telling you.
And she should have had them bailiffs get up, put the paws on him, and make him sit his ass down like she did during preliminary hearing. Didn't she excuse the jury? So they ain't gonna see nothing. Turn them cameras off and get him to sit damn down. End the story. This don't have nothing to do with no appeal, y'all. This has nothing to do with an appeal. She can make him sit his butt down. Period.
Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August. And there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics? Is my first question.
Okay, why was it an issue with me bringing
Mr. Brooks, I'm only going to ask you one more time, and if you don't answer it
if I don't
correctly,
understand,
then
if I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
it calls for
I don't
yes or
I don't
no.
like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks,
appreciate it.
Sit down. I don't care if you don't like my tone. You've been pushing my buttons all day throughout this entire trial, and I have showed the utmost of respect for you, and I don't appreciate you impugning the integrity of this court.
If that's what you want to call it, that's fine, but it's not accurate.
Stop talking.
What you mean, stop talking?
I need to make a ruling. Okay, well, I'm purposely not putting you in the other courtroom right now.
Let's talk to each other like adults then. Because I've never told you to stop talking.
You can't.
I'm going to ask this question one more time. If he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the question about the jail cell?
You've not answered my question. We'll move on.
I'm trying to understand. If I don't understand, how do I know? How do I know what I'm supposed to answer if I don't understand? And I don't agree to a stop.
All right, let me do that again. We are back on the record. State versus Brooks appearances are as they were before.
I don't consent.
Hold on, let me catch up with these comments. Let me check on y'all. Excuse me. Mm-hmm. Hey, Christine, how are you? We up late, okay? Right. There was no reason why she couldn't get the bailiff to make him sit damn down. Goodness. I mean, I get it, but that's why you got bailiffs there. She has too much that she can do to get him under control. You know what I'm saying? And so, like somebody else just said, the moment that she was just too nice and too accommodating to him, see, people like him will take advantage at any given time. If they see that, that they can kind of weasel in and kind of manipulate you a little bit and just take your kindness for weakness, they're going to play on that. And that's what he did. And I understand she has to be impartial, but still, the fact that when she started mentioning, oh, I'll give him a little leeway or, explaining things or over explaining, That's when he started to take advantage of her and then giving him all of these opportunities. This is your final warning. Absolutely not. I'm going to ask you one time. You either answer me or not. And if you choose not to, I'm moving on. If you don't shut up, I'm going to make them make you shut up. And if you still give me a problem, you're out of the courtroom. Period. That's the end of that. No, it just got to be too much. Excuse me. She did. Girl, I'm getting tired, but I'm hanging in there. How was your day? Woo! Like, there's no way you got them big husky bailiffs up in there and you told him to sit down and he ain't sat down, talking about you telling me or you advising me or whatever he said. No, you wouldn't be disrespecting me like that. You sure would not. We still here. We almost done, no. So, but why not yell at him? That's what I don't understand. You can't just say because, and I'm not talking about you, Annie, I'm just saying in general. You can't just say, oh, well, because he represented himself, she couldn't. Why the hell not? If he's acting as his attorney, you're upholding him to the same standards that you would the prosecution. Why not? They can't get up and throw a tantrum because they don't like what she says or they don't like a ruling or they don't agree to it. You suck it up and move on. So why is this case different? Why? Because guess what? Even if he is granted an appeal, that does not mean that they're going to rule in his favor. It just means that they will hear what his attorney has to say as to why the case should be over, his conviction should be overturned. And guess what else? Just because even if he's granted an appeal, he can't they can't overturn the entire conviction. They have to grant on certain, they have to file an appeal on certain things, and then the court has to decide, okay, if we're going to overturn this specific charge based on this specific grounds. So what? Let them appeal it and let them do that. But you're not going to disrespect me. You're not going to embarrass me. Absolutely not. That wouldn't have, let him appeal. So the hell what? You're not going to do this to me, especially when I'm giving you a direct order to do something. You're not going to tell me that because when she gave him a direct order and he chose not to follow it, and then her just sucking it up means that what? That's protecting his right to not have an appeal. That doesn't make any sense. So what? So what? They still have the power to take charge of that courtroom. Let them cry. Let them cry. That's why you document. That's why you have cameras in there to capture everything. Because it's no different. If he was just a defendant and he had attorneys, she has the power to bind and gag him, right? And the bailiffs will have to manhandle him to do that. So in this case, she can't do that. But you can get them to make him sit down and shut up, especially while the jury's not there. I'm not hollering at you, Kelly. You know, this is just my personality. I'm just saying it's gone on too far. It's just like a child. When they know that they can take advantage of you, they will do it. Especially when they know that, okay, my mama's going to let me talk back. My mama's going to let me do this. My mama let me sneak out the house and she's not going to do anything. Or even if you do punish them, it's not to the extent that they should have been punished. So they're going to keep trying and keep trying and keep trying, right? It's the same instance here. Every day it gets worse and worse and worse. And she does nothing but grow more and more frustrated with him because she's lost control at this point. If that's the case, don't even have bailiffs in there and take the the shackles off his damn feet then and just let him do what he wants to do. Well, good morning, my love. Hey, boo boo, how you doing, love? Y'all know what I'm saying? Take back your courtroom. And like I said, let him appeal. Mostly all criminals that are convicted will appeal. Even though they were given a full trial, they will still appeal. Just off the strength that they can do it. It's their right. Look at Lori Vallow. She know damn well what she did to her family. She appealed. She ain't gonna get out. They're gonna deny that, but she still did it. So it doesn't make a difference. And this is just my opinion. This is how I see it. No. Excuse me. The only thing I have to say about that is I wonder if he was drugged up. Have they started giving him drugs in court? And maybe more so because he just didn't care about that case. And I think that his mom was in the nephew's ear about just not wanting to pursue those charges. I don't know. You know, I'm not saying you're wrong. I'm just saying what I think. They haven't said. He just filed an intent to appeal. That's just letting the court know that I'm complying with the order that within 20 days I am going to appeal. His lawyer, okay, has received the transcript. So now it's his job to go through those transcripts and see what they can use to appeal. The trial court will then decide if they want to hear the lawyers. What am I trying to say? Hear, the lawyer's side about, I can't think of the terminology right now. Basically hear why they feel that they have grounds for an appeal on specific things, not the whole conviction. The trial court can say, nah. So then they will and can appeal to the Supreme Court of Wisconsin. So we don't know yet what he's going to try to appeal on. He ain't gonna get no near an appeal. I know, Fee, okay? I know. And I know you came in here to set us straight. Well, you know what? She got made a fool of, in my opinion. Mhm. I mean, that's true. You don't know what they said, but still, they're not your boss. That's just somebody you work with. She probably just was like, well, do you think I'm being too soft or should I go harder? Or what do you think happened in this instance? But ultimately, it's your courtroom. It doesn't matter. It doesn't matter. You go as hard as you want to without violating a person's rights. You're not going to violate his rights because you elevate your voice, because you change your tone, because you get your bailiffs to make him sit his ass down. Period. I have seen a case where the judge literally ordered the bailiff to take some tape and put it on this man's mouth because he wouldn't shut up. Now, granted, he wasn't representing himself, but if they can do that, clearly, Judge Darrell, you can use these big bailiffs to get him to sit down and shut up. Exactly. I get all of that, but still, no. Ain't no kill with no kindness when you're in a position of power. You are in a position of power. It's disrespectful to the victims. It's disrespectful to the families. It's disrespectful to the prosecution. Because if they do that, guess what? They're held in contempt of court. And I'm not yelling at you. I'm just trying to make a point here. So, no, no. In my opinion, no. Even Sue Opera just sat up here and apologized for her tone because she's frustrated. And you let this fly? And these people are in this courtroom. Who knows the strength that they had to get up every day and come to court to listen to this mess. And their loved ones are dead. These people had to take off work to make sure that justice will be served. And you letting this man do this? No. Mm-mm. No. No. Mm-mm. Mm-mm. This is too much. And at what point is it egregious enough to use for you to say you're done representing yourself? Let's get somebody else in here and you sit down and shut up. At what point? Does he have to jump on the table, start throwing things? What? No, it could be anything. But it's up to that attorney. That's why it's going to take it could take years. He has to go through all of those transcripts and see what he can do. And who knows? He might find something that he could try to use, but that doesn't mean it's going to be successful. And it's not going to be successful or unsuccessful based on what or how nice or how willing Judge Darrell was to explain things to him. Mm-mm. I'm not hollering at you. I'm not. I hope you're not taking it that way. I'm not. It just upsets me because the prosecution can't do that. They can't. They can't. And so he shouldn't be allowed to either. Mm-mm. Mhm. Mhm. Yeah. So I'm not hollering at you. You still my boo thing. I'm just saying, you know, it has to be balanced. It has to be. Mhm. Mhm. Like I said, I mean, some of it I get, but it has to stop at some point. You talking over me, telling me what you don't have to do? No. No. Mm-mm. What you mean, the man that told him to burn in hell? Like, mm-mm. He's always gonna be one too. He don't give a damn. And see, that's the thing. He doesn't have anything to lose at this point. Nobody in the gallery can shout out in anger, right? Soon as that man told him to burn in hell, she removed him. Somebody else told him to be quiet. You can't never shut your damn mouth. She removed them. But you give him all of these chances to continue to be disrespectful, even after you pled with him many a times. Mm-mm. Mm-mm. No. Mm-mm. And he got removed immediately, right? Nobody right now during this whole situation can stand up and do what he's doing, which they have every right in my eyes to do because they're pissed off. My family member is dead because of you. Children are injured because of you. I can't just jump up and start yelling, but he can. You got a whole bailiff sitting behind him. Mm-mm. It don't sit well with me, y'all. I'm sorry. It just doesn't. Mm-mm. Let's see how much more time we got on this.
For the record.
Are there any issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
No, Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has. So I believe we are good on that.
I have one question
sure.
about Exhibit 89, and I don't know if I missed in my notes.
Okay.
What do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a certified bail form.
No. I'm asking.
Oh.
I'm asking Mr. Brooks. So,
sorry.
That was the second of the two bail bonds. Do you have a recollection of whether it was received?
I don't.
Right. Then what was?
I objected to it.
I know you objected when it was, I think, displayed for the witness who then testified about it. I'll receive it and also advise the jury. Were there any other exhibits? I have one other issue on evidence and exhibits as well, but are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
I don't believe so. I know at one point someone caught that we moved, it was either Exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
So maybe just had a misspeak.
Yeah.
You have any recollection of that, sir?
Recollection of what?
Related to what the state just put on the record. Do you know what witness that was?
That was Detective Kate.
What's the request then as it relates to when the jury comes back in?
Your Honor, I just, there's two different ways to do this. I can put on the record, I have the exhibit numbers, and I can just put on the record just to verify that these exhibits have all been offered and admitted into evidence, and the court's agreeing, because we've just agreed that those are, your records are the same as my records, or we can clarify just if there was some confusion about exhibits 175 and 178 that were shown to the jury this morning. Those 175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
All right, sir, do you have any position on how I address this in front of the jury?
Yeah, I'm objected to it being admitted at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but
No,
the fact that I've already ruled on the
Definitely.
admissibility is not something I'm going to revisit.
What I have to say about anything definitely doesn't matter.
I take huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt, you try to debate the topic again and again, you make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes. I mean, just previous to the break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for
Girl, you didn't raise your voice enough. Now you want it. Oh boy. Yes, she could have. Mhm. Hey, Sherry. How are you? Good night. I think we got a couple more minutes. Y'all, what time is it? 1:22. We kicking it, y'all. All right, let's see how much longer we got on this. She's sitting up here explaining herself.
me. We had had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings because frankly, I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on. Now, with respect to, I want to also address exhibits and the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was frankly to assist the court and my clerk in keeping track. Most trials, the normal course of action is as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal. We're not quite there yet. That as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement unless a judge orders it that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit. There was nothing.
And see that right there? I would have stopped talking and moved on. She's trying to do him a favor by explaining to him how evidence is entered into the record and the fact that typically, most often, if not always, your evidence is turned over. There has to be a demand for discovery by the defendant, the defense team, in which the prosecution will turn it over, and any new evidence that they come across, they have to let it be known and provide it to the defense He don't give a damn what you're talking about, Judge Darrell. So let's move on. Because guess what? This part here does not have to be part of the record for an appeal at all. She's doing him a favor by explaining something to him. She doesn't have to do this. So that part is irrelevant as well. He's being very disrespectful. He doesn't care what she's telling him. So why even talk about it? Oh, what you guys have for dinner? Yes. Thank you so much, Tim. Oh, thank you. Let me see. I wonder if his mom still works at the hospital, if he was my son. From my understanding, she does not work at that hospital any longer, and she sold her house and has an apartment now. So let's wrap this on up.
Improper about what the state did with Exhibit 178. And I want to make that record very, very clear. As Attorney Opper stated, trials are fluid. Things happen. Parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other acts evidence with Erica Patterson. And I frankly kept it out despite your questions. So with that, I want to bring the jury back out. I will ask the state, I'll simply just ask the state, are there anything additional the state's offering by way of testimony or exhibits? You can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony. Before I bring the jury out, there's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
So is that addressing subject matter jurisdiction that you're pulling up?
No.
When would that be proven for the
Sir,
record?
please don't interrupt me. I need to focus on what I'm doing.
I'm not interrupting you. I'm just asking a question.
All right. I'm not going to be addressing that. So
would it
don't
be proven
interrupt me right now. I'm trying to do something on my computer.
Would it be
I need to
proven on the
focus.
record?
Here we go
It's
again.
important at this time to at least give you the advisement pursuant to Special Material 28. It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed, not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not.
What's the significance of that?
So that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
That's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then, and we can kind of tidy up the record, and then we'll break for lunch.
May I remove that exhibit, please?
I think they're right there. Jury instructions, that just has to do with opening statements. I will read that with the caveat. It will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statement is not evidence. So I'll read that. I think it's appropriate given that Mr. Brooks deferred his opening statement until the start of his case. With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to go at 1:30 with your opening statement.
I got a question.
Go ahead.
Do I get to present exhibits and stuff like that too and admit them into evidence?
At what point are we talking about? Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they documents from the discovery that you have?
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer.
Give me
for
an
evidence.
example, please.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings, everything
Which
that I filed.
filings, sir?
Every one of them.
Well, they have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm
filings.
in general based on what I've seen thus far. So are you talking about during your opening statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I've filed a number of documents. I think that's on the record
without
that I
knowing what
filed.
you're referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They will only be relevant to obviously the matter. They would
Sir,
be relevant to anything
I
else.
can't answer that anymore. We're gonna take our lunch break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
So I'm not allowed to offer anything in the evidence.
For the record, I never said that. We are in recess.
So I'm trying to understand.
Session, State versus Brooks, appearances.
All right, we done. Cause guess what? We did this opening statement last night. Let's see what you're saying. I can't spell the dish my daughter made, but it was Mexican meatballs. Oh, what are Mexican meatballs? Spanish rice and black beans. That sounds so good. I'm so hungry right now. You know, what does your name mean? Hey, Melanie. All right, y'all. We've been on here for 5 hours. This is the longest live that I've ever done. But I had a phenomenal time with you guys. And I appreciate all of you for thugging it out with me. Even when we disagree, we still love each other, right? I think we got up to like 82 viewers. Okay. So tonight, since we are on a new day, I think the live for tonight is the 50-minute rant, but I have to do some more research because I want to give a little bit more of legal analysis to that 50-minute rant. And then I want to try to drop part 2 of the Tamir Rice investigative report. Let me see. I think that's all I have. But I homeschool my kids during the day, so that's first and foremost. And then once I'm done with that, I'll get busy on everything. So the live tonight is at 8:30 p.m. Eastern. And I want to try to do my best to keep it at like 3 hours. So I want to at least try to be done by 11. Oh, we'll see how that goes. You know how it goes with us. But I'm going to try my best. I will be dropping content every day this week for you guys to enjoy. So it'll be a nice mix of Tamir Rice, Darrell lives, Darrell videos, and then I think I'm gonna do some Sarah Boone. I know I had somebody reach out to me to read her letters, so I will read them and provide legal analysis as well as commentary and my awkward opinion. So that is what is going to take place this week. I did upload a itinerary on my community tab. So I do appreciate you guys so much for hanging in there with me. Let's see what the final comments are saying. Oh, Mother of Education, that is beautiful. That's beautiful. Thank you, TY girl. I'll see you tonight if you can come. Bye, Maya. I hope to see you tonight, and I hope the rest of your shift is amazing. Thank you so much, Melanie. I appreciate you so much. Thank you. Thank you, Sherry. Thank you. Thank you, my good sis from California. Thank you. If you do have time, I do appreciate you so much, and I will shout you out for looking for it. It's no disrespect to any other channel. I just like to, do my own stuff. Because we all work hard to get the information that we have. So I don't want to just steal somebody else's stuff. So I do appreciate you, sis. Oh, thank you so much. It's no problem at all. I do enjoy all of you individually and collectively. Yes, we will be back tonight if you can make it. Thank you. Enjoy your Monday. Enjoy your day, everybody. Thank you so much. Thank you. Thank you. Bye, Debbie. Bye, Monica. I'll see you guys tonight if you can make it. Get some rest. Everybody be safe. Have a productive day, you guys. I appreciate you so, 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 so much. We are at 734 subscribers, y'all. We're getting there. We are steadily growing. I appreciate y'all so much. All right, y'all, be easy now. Okay, be easy. Peace.